function as far as Muslim teaching is concerned. Now, my lord. I'm going to forget.
The first statutes are by the Governor General in Council, and no amendment can be made without him.
Has to be.
No, it has to be.
We can reject.
Yes.
We can reject.
No, without him.
He
He is the complete source of statute and ordinance.
Disallow or remit. That's all.
Now, my lords.
And actually, this act was made, my lord, under the 1909 Council, not 1919 Act. Because the 1919 Act came into force on 9th February 1921 after the first elections. So the Council Act was continuing, my lord, and the Council was nothing but the officials and a few nominated members.
So who enacted this act then?
Governor General in Council under the Act of 1909.
Or 1909?
Indian Council Act 1909. So though the Government of India Act is of 1919, it came into force after elections on 9th of February 1921.
In fact, it says that passed by the Indian Legislative Council and received the assent of the GG on 14th of September 1920.
The council was earlier also there, but this diarchical system came later.
By the 1919 Act.
And therefore, by rules, not both these institutions, BHU, and they were kept with the Governor General Council, and rest were transferred. Education was transferred to the provinces by rules.
My lord, we are not denying that in the imperial statute, my lord, this overriding power with the Governor General existed, as your lordship. We're not denying that, but it doesn't take away, as we'll explain further, my lord, it doesn't take away from the power of the court as a proposing body or otherwise. So the initiation, my lord, in effect comes from the court. Now, my lords, I come, my lord, now to, no, I don't. My lord, kindly come to the statutes on PDF 16.
Just see page section 30, ordinance, or the section 30, or the power to make ordinances.
Which section was your lordship?
Section 30.
30. The Executive Council, my lord, I marked it, or in academic matters, the Academic Council may make ordinances. I'll tie this up, my lord, when I read the statute.
And then 30, clause 3.
No new ordinances or amendment or repeal of any existing ordinance shall have validity until it has been submitted through the court and the visiting board, which may record its opinion to the Governor General and has obtained the approval of the latter. So, my lord, here is an important aspect that comes through the court.
And 30, clause 2 says the first ordinances will be as framed by the Governor General.
Yes.
Council.
And no new then can be made without it.
That was an interim measure, my lord, the first ordinances. We're now looking at the change and who had the power. The power, my lord, here is through the court and the visiting board. Now, the visiting board, as I'll show to your lordships, my lord, that provision has been deleted later on. Now, my lords, 31. The authorities of the university may make regulations. And who are the authorities, my lord? The authorities, my lord, that have been mentioned at PDF 11, my lord, in section 22, which I've already read out to you. And the authorities here are the Chancellor, Pro-Chancellor, VC, Pro-VC. The court, yes, of course. I've already indicated that they'll be appointed and elected. I've already indicated that. My lord, I don't want to go into it further. Then, my lord, 31.1, my lord, on PDF 14. the authorities of the university, and I've indicated who they are, may make regulations consistent with the Act, statutes, and ordinances. The Governor General, my lord, doesn't come under the authorities of the Act. And then 31, my lord, sub-clause B in 1, providing for all matters which by this Act, statutes, or ordinances shall be prescribed by the regulations. Then, my lord, every authority of the university shall make regulations providing for the giving of notice to the members of such authority, dates of meetings, and of the business to be conducted, or keeping a record of the proceedings. So, my lord, it is the authorities that become very central. And when I read the statutes, it will become clearer. 33, my lord, I've just mentioned 32. Said admission of students, my lord, shall be made by an admission committee consisting of the Pro-Vice Chancellor, the principal of an intermediate college, who shall be selected by the Vice Chancellor, and such other persons as may be appointed by. Here, my lord, it's without the reference to the external bodies of the Governor General or the visitor or rector, as the case may be. Then, my lord, section 33 on PDF 15. So, my lord, there is some overlap, residuary power in the governor. There's no doubt about it. We're not saying that. But the mobilizing factors remain the court. And then 33, my lord, that is on PDF 15. All arrangements for the conduct of examinations shall be made, and all examinations shall be appointed by the academic council in such manner as prescribed by the ordinances. So, my lord, it is the entire administration moves in, apart from that residuary power that your lordship has pointed out. And then what follows from these powers, my lord, is explicated in para 50. That is the right to appoint, the right to governing body, etc., etc. And TMA Pi makes this abundantly clear. Now, my lords, statutes. Why do you want to say it? Now, my lord, the Vice Chancellor, as I've shown to your lordships, is appointed by the court. I've already done that. Now kindly come to PDF 17. That is statute number 3. The Vice Chancellor shall take rank in the university next to the Chancellor and Pro-Chancellor, and shall be ex officio Chairman of the Executive Council and Academic Council. In the absence of the Chancellor, and Pro-Chancellor shall preside at convocations held for conferring degrees. Then there are certain emergency powers, my lord. Then, my lord, your lordships may kindly come to the treasurer, my lord, in statute 5. The treasurer shall be appointed by the court on such conditions and for such period as the court may think. So the court, my lord, comes in as the appointing body and as far as the terms are concerned as well. Then, my lord, you come to statute 6 relating to the registrar. The registrar shall be a whole-time paid officer of the university appointed by the court. So all these appointments, my lord, that are crucial to the administration are in fact appointments by the court. Now, my lord, and the registrar's functions are. Now, my lord, I come to the very important aspect of statute number 7, The following of officers shall be appointed by the Executive Council on the recommendation of the Academic Council. That's the proctor and the librarian. This is an important internal part of the administration in which that overall vetoing power is not there. Then, my lord, I come to Statute 8, which is absolutely fundamental. Finally, first come, my lord, as to who are the ex officio members. Now, kindly read the ex officio members, my lord, along with 23 provisions. Because once they become members of the court, they automatically, my lord, are Muslims. So who are they, my lord? The Chancellor, Pro-Chancellor, Vice-Chancellor, for the time being shall be ex officio members. But by virtue of being ex officio members, they must necessarily be Muslim if the proviso to 23(1), my lord, is to be taken into account. Now, my lord, kindly see foundation members.
As a matter of fact, they've been always Muslims?
Sorry? Yes.
As a matter of fact, they've been always Muslims?
Yes, yes. My lord, I'm first dealing with the de jure argument, and we'll come to the de facto later. De facto, as has already been pointed out by Mr. Shadan Farasat, my lord, that argument has been spelled out, therefore I don't need to repeat it. Now, my lord, kindly come to the foundation members. Of the 180, my lord, 124 were foundation members. Necessarily had to be Muslim. To read it, my lord, along with 23 proviso. And this is 124 at its inception. Naturally, they continued to be less and less as we moved on. So 124, my lord. Now, my lord, the next one is life members. This is all part of the court, my lord, and that's the important part. They all have to be Muslims. Then, my lord, ordinary members shall be elected or appointed as follows: 10 persons to represent states in India. And these 10 persons also, because they are members of the court, they have to be Muslims. Then, my lord, 60 members who make a donation, as long as they are...
Just 1 second.
Affectionately, the important point in statute number 8 is they all have to be Muslims.
Statute 8 says that the court shall consist of the following members.
That's right.
The proviso to 23(2) says every member of the court has to be a Muslim. Therefore, that will apply to every person who is defined to be a member under Statute 8. That's
because earlier your lordship did indulge is not the right word, my lord, in some mathematics about 20, 34, etc. Actually, all of them, every single one of them, will have to be a Muslim.
De jure. I mean, that's apart from Shadanza.
I'm on de jure, my lord.
Yes.
De facto has been argued, and to the extent I want to refer to it, my lord, I'll refer to it. Now, my lord, therefore, the 10 persons to represent states, by virtue of the proviso, will have to be Muslim. Then, my lord, 60 persons elected by persons who make donations. My lord, by virtue of the proviso, they will have to be Muslim. Then, my lord, we come to 20 persons elected by the Standing Committee of the All India Mohammedan Educational Conference from amongst its own members, not less than 10 of whom shall be members who have engaged at least 5 years in teaching. They have to be, my lord. Now, 7, my lord, is very important because all members of 15 members, that subsection, that's 7. 15 members to be elected by the academic council from amongst its own members. Who will they be, my lord? They will be Muslims. By virtue, my lord, of going into the proviso read with Statute 8. So predominantly, my lord, across the board, they have to be Muslim in that first phase. Therefore, my lord, 15 of the persons in the academic council has how many? 28. Therefore, 15 of those 28 in the academic council will necessarily have to be Muslims. Then, my lord, Statute 9. The members provided for in classes 1, 2, 3 and clause 1 of class 4 shall be members of the court. Now, my lord, kindly come on PDF 21. The Executive Council shall consist of not more than 30 members. Vice Chancellor, Pro-Vice Chancellor, Principal, Intermediate College, who shall be elected by the Vice Chancellor and the Treasurer to be ex officio members. But here, my lord, subclause 3 is important. That's Statute 15(3). 6 other members shall be elected by the Academic Council and 20 shall be elected by the court, of whom not less than 7 shall be residences from outside in the United Provinces. May I come to Statute 16, my lord, which is important. I've already indicated the composition, my lord, of the Academic Council will necessarily 15 of them. Then, my lord, if your lordships will come to Statute 16 in PDF 21. The Executive Council shall, subject to the control of the court and to the acts, statutes and ordinances, administer the revenue, properties, regulate the finances and so on. So the executive court will be subject to the control of the court. Then, my lord, footnote 3, want what read? Yeah, I've read that. 15(3), 6 other members shall be elected by the Academic Council, and 20, that's important, I'm sorry, you were right. And 20 shall be elected by the court. So, my lord, there are 20 there that shall be elected by the court. Then, my lord, 16 I've read under the control. Now, my lord, kindly come to the Academic Council. I've already indicated that 15 members of the Academic Council are part of the court, and therefore necessarily, my lord, those 15 in the Academic Council will have to be Muslims by virtue of the proviso. Now come, my lord, to Statute 17. The Academic Council shall consist of Vice Chairman, he is a member, my lord, of the court, Librarian and Proctor by the EC. Then, my lord, kindly come to PDF 22. 2 persons elected by the court. Now we add to these the 15 members, my lord, which we have indicated, my lord, who would be part and parcel, my lord, of the court and therefore members. Then, my lord, various, I don't think it's relevant directly to the control, but the departments of studies, your lordship has seen, we've already pointed it out, Sunni theology, Shia theology, and so on. Now, my lord, come to Statute 20, PDF 23. 20 is very, very important, my lord. Subject to the general control of the court, all appointments in the teaching staff shall be made by the Executive Council from a list of persons recommended as suitable, therefore, by the Committee of Appointments, consisting of Pro-Vice Chancellor, Chairman, Department of Studies. So here, once again, my lord, what we see is subject to the general control of the court. The foundation members, my lord, has already been shown to your lordships on PDF 24, 25 and 26. Well, all the way through. They're all Muslims. So, my lord, what I'm indicating to your lordships, although 51, my lord, which was said to be just to bring it up to date with the Constitution, 65 was an emergency measure, which is rectified to some extent in 72 and 81. And in 81, my lord, there is a full restoration as it was in the
Can we
1920s.
go to briefly to the 1951 now, so that we can see what is the next? We'll
Just show me.
The evolution is then complete.
My lord, I cheated a little, my lord. I'm relying on this. It was easier for me.
I
Because
noticed
marked-
that you are not on your iPad.
No, it will go further and further, my lord. I told you he's my guru. If he can do it, I can do it.
One of my
Give it to
cousins
me.
was in the.
Show that chart.
Well, the solicitor had indicated a chart.
What do you think?
Now, let's see the statute itself.
Actually, but to show from the changes.
Good.
I will do that.
I'm sorry. What's wrong with it?
4A or 2?
Is there. So it's also there in volume.
I wanted to. Take it from the chart, my lord, which the solicitor, or does your lordship want to see the statute?
Could we just quickly go through the statute, because
Yes.
it's much better, you see the statute
Yes,
as
it
it
is.
stands.
It is.
The chart is excellent, but just, since we are at it, it may take 5 minutes more.
Might as well
And
see it in its
51,
totality.
let's see what 51 does now.
Certain
I thought we
glitches.
can spend a little time, because this is really the heart, also what about administration,
Yes,
the du jour, as you said.
that's certainly.
So let's go to the 51, what 51 does now. Apparently, the founding members were to retire after 5 years, like the Council of States, like the Rajya Sabha. So many people would retire after every year after 5 years, and they were eligible for re-election.
That indubitably, my lord, indubitably. So this is the 51 Act.
Now, 1951 is volume 4A.
Did your lordship want to see the 51 Act as well?
Yes, I think we
Yes,
should
certainly.
just have a flavor of what
Certainly.
happened there.
My lord, what is the PDF
This is
of?
page 4A, the volume 4A, page 19.
4A, page 91. Now, my lord, an act to further amend the Aligarh Muslim University. Act is called the Amendment Act, my lord. 30 and 31 shall come into force at once. section, and the remaining provisions of the Act shall come into force on such date as these are, my lord, machinery provisions. Then, my lord,
I'm sorry, I missed out the page number, PDF page number.
page 90.
90, page volume 4A.
इसमें क्या कर दिखाना है बता rapid fire. Then, my lord, your lordships will see section 2 of that act. No, nothing much there.
Section 5
Yeah.
needs to be looked at.
Page 91.
91.
Back up.
So, my lord,
T1.
91, section 5, which is really the section.
Pending section 8.
Classes, castes and creeds.
This is now a substitution for section 8 that I've read out to your lordships. University open to all classes, castes and creeds. The university shall be open to persons of either sex or whatever race, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever of religious belief or profession in order to entitle them to be admitted therein as a teacher or student. What was section 9 and
Compulsory education. People will do. This is curriculum 9.
your lordship reads section 5. Aziz Bhasha is right in saying that these were to bring the statute in conformity with 28, my lord, and 29 too. So that's the change that is made in section 5. Then I'll take your lordship to section 8.
29. Section 6.
6 में क्या कुछ नहीं है.
Deletes 9, na?
Hmm.
Section 6 deletes 9.
If there is any provision which, there's just, you can tell us so that we'll read that as well. Yes, section 8.
What is section 9?
Section 9 was compulsory instruction, na, which was deleted.
9. That is, my lord, section 6, my lord, it deletes the compulsory education part. And this is again consistent
Religious education.
of religious education.
Completely omitted.
Then, next one.
The word code.
Section 10.
What rector is 10.
Section 10.
10 is important. Section 10. For the words Lord Rector, wherever they occur, the word visitor shall be substituted. So, my lord, the visitor's power is there in every statute, my lord, whether it is a minority statute or otherwise. Then,
Stands omitted.
now, my lord, section 14.
No, just read the.
In no act, Lord, of in any other act of university, the visitor has power to approve, amend, etc. the statutes and ordinances.
It is there in Central University, my learned friend is wrong.
State universities talk about
Talking
it.
about Central University.
This is not a central university. This is not a central university. This is not central.
Lord, when I was president of the Cambridge Union Society, my lord, we followed the rules of Parliament, which was somebody gets up, I accept his intervention or I don't accept his intervention. I don't accept that intervention, my lord, for reasons stated by Mr. Sibal. Karan Thapar goes on and on. Why didn't We are the only father and son, my lord, who were presidents. Just an aside, my lord. Now, my lord.
Becomes executive council.
Right.
And for the word courts.
Where I,
Right, section 10B, as Mr. Sybil said.
Yes, that's
court
right.
Becomes,
executive council.
For the word court, wherever it occurs,
Executive.
the executive council. And there is in 10, my lord, in C, the visitor shall in every case give notice to the university of his intention to cause an inspection or inquiry to be made, and the university shall be entitled to appoint a representative who shall have the right to be present and be heard. Now, this brings in a very important element. Then,
Just to clarify, in section 10, court is divided as executive council only for the purposes of section.
that's right.
Just to.
No, that's important, only for the purpose.
oh, it says for the word, right, in section 13.
Only with respect to 30, not otherwise.
I accept that intervention, my lord.
Guru's intervention has to be accepted.
Now, my lord, section 11, my lord,
This happens in parliament also, Millets, because somebody gets up and the person who is speaking, Millets, says, please yield. And I have to decide whether I yield, or whether I yield or not. Or I don't allow.
perhaps your lordship can be a little more lax, my lord, in court.
If you don't yield, Millets, you cannot enter.
Oh.
But nowadays, shouting goes on, so that.
Now, my lord, section 14.
section 14 is the visiting board, Chitta and Sriti.
Now, my lord, there was a visiting board in section 14. I'm instructed that board never met. And therefore, my lord, that provision for a visiting board, which was an extra, has been deleted by section 11. Then, my lord, certain substitutions, because the governor, my lord, then becomes the chief rector.
Chief rector, governor.
And that is in section 12. So these are machinery provisions to bring things in line with the constitution.
It says successors of the first vice chancellor to be appointed in accordance with the statutes.
11. और क्या?
In section 17, the proviso is deleted, no?
Important part, my lord. 17, the proviso was deleted in section 23. And Basa says that in effect in this statute, there was no substantial change that was made. Those
But Mr. Dr. Dhawan, would the deletion of the proviso to section deletion of the proviso to section 23 not be a very important change, because until then, no person could be a member of the court in law unless they were Muslims.
right.
Now, post 1951, the requirement of having a Muslim as a member of the court is completely done away with.
Except, my lord, that I've already shown to your lordships that many of the members of the court had, by virtue of phase 1, necessarily had to be Muslim. This is removed in phase 2.
That's in phase 2 that is removed.
That's right.
No changes, legal things have happened on the ground.
Now, my lord.
This is because if, we proceed on the basis that the court was a supreme executive authority, and post 1951, therefore, the membership of the supreme executive authority is no longer defined by religion. You could be a member of any religion to be a member of the court.
That, my lord, is a consequential amendment from the Constitution.
No, not necessarily. You may still have, even today, you may have a managing committee of, say, an educational institution where the entirety of the managing committee consists of Parsi Zoroastrians, Christians,
Yes.
Muslims, or whatever.
So this is significant, my lord. I'm not saying
that
it's
is significant. We'll have to.
And we were right, my lord, your lordship was right in going into the statute itself. No? Section 19. Is the power to make statutes which will provide for the constitution, power and duties of the authorities of the university, which I've indicated already, my lord, earlier. Election and continuance in office of members of the said authorities, that's a continuation clause, including the continuation in office of the first members and the filling of vacancies of members and all other matters related to those authorities for which it may be necessary or desirable to provide. The rest, my lord, are not important, except section 20.
Where 20 subsection 6 now says, any amendment to our statute or a new statute requires the previous approval of the visitors.
Yes. So this happens, it is inherent, my lord, in the nature of the visitor's powers. That's the powers of inspection and otherwise. Now, my lord, we come to 20, section 20. Subsection 2, my lord. The court may from time to time make new or additional statutes or may amend the repeal of the statutes in a manner indicated herein. So, my lord, the court comes back and may from time to time make new and additional statutes or may amend the statutes, and the procedure is that the Executive Council will propose, and then finally, my lord, in subsection 4, the court may approve any such draft as referred to in subsection 3 and pass the statute or reject it. So the court's power, my lord, to that extent are there, my lord, in substituting section 28, and the court's power, my lord, are certainly there as far as the statutes are concerned. I don't think there's anything more. Let me take your lordship to the 65 Act, if I may, my lord.
Subsection 4, there's
Just
an
one-
appellate power given to the central government. On the statutes, if there's a difference between the.
Yes. So, my lord, all that happens is in accordance with the Constitution. That's one part, my lord. And the second part, the court's powers are made subject to, as the rector's powers or the visitor's powers are made subject to the court. And then, my lord, court eventually has to approve that, my lord. I've already pointed that out.
21(7), the visitor can suspend the operation of any, so 21(6) and 7 may suspend any ordinance.
Power of repeal.
My lord, this is a backup power in the visitor, with many variations, my lord.
It is a provision that 21(4) is just which meeting
The proviso, my lord, to
section 4.
subsection 4 is provided that if the ordinance is not approved by the court at such meeting, it shall cease to have effect. That is section 4.
25A, the auditors are no longer now appointed by the visiting board, but by the Comptroller and Auditor General of India.
Yes.
See section 25.
Not here.
Yes, it's 51 only.
Thirty-two. Now, section 24, my lord. I'm making a distinction, my lord, between the internal administration, in whose hands it is, and the external, my lord, supervisory or other powers, as the case may be. So, my lord, if your lordships were to look at, your lordship was on 25, the auditors. The Controller General comes in, my lord, which is a salutary provision.
And in this 1965 Act, somehow missed that actually.
President of India.
Which provision?
In the 65 Act, my lord, what happens is this function becomes advisory.
But how, where is the expression visitor defined in the 65 Act? Actually, I was just checking that out.
51 Act, my lord?
No, we are now on the, we are on the 51 Act, sorry.
Yeah.
How is the expression visitor defined? Somehow the other, I just seem to have missed that actually. Well, I was looking.
Section 13 minutes.
Section 13. Section 10.
Yes. The Lord Rector, wherever they refer, the word visitor shall be substituted.
But how, no, but who is the visitor?
Governor.
The Governor General.
Where do we get that?
The Governor is substituted, my lord.
Section 13, Governor General becomes the President of India.
Right. Section 10 says visitor is substituted for Lord Rector for the purpose of Section 13.
Yes.
Then Section 12, Governor of UP becomes the Chief Rector. But where do we have in this 1951 Act, who is the visitor? There must be some provision defining us, defining, who is a visitor.
Who is the visitor? Just give me a
I
moment.
was checking whether, there is an amendment to the,
Originally, it was the Governor General, but then as soon as we became independent, but the President.
Governor General was the Lord Rector.
That's right.
Though the Act used the expression both Lord Rector and Governor General in Council separately.
Because
Right. And then comes
Lord
in.
Rector was changed, but the Governor General became the President. The Governor General, the President of India took over the function of the Governor General.
Right, under the Constitution.
Yeah.
That must have been under Article 370 or something.
Yes, exactly.
But, 372, sorry. But what about the visitor, and who is to be the visitor in this Act, unless there's a casus omissus there?
Is there any provision?
He only replaced the word Lord Rector in Section 13.
Who's the visitor?
That's all that it is.
No, the word visitor would have been still defined somewhere.
Somewhere.
It cannot be. This cannot be.
Finally, the original Section 13 minutes will make it clear. Volume 3.
Yeah, we have that opened actually.
Original Section 13. Have a look at that.
Because, my lord, the Lord Rector under section 10, the word visitor shall be substituted.
Who is the visitor?
Therefore, the two it's a matter of substitution.
Okay, so what happened was the president became became the Governor General, and because of the Lord Rector got substituted
Yes,
by
sir.
visitor there, that's all.
And this is all to bring things in conformity with the Constitution.
Oh, right, because actually it was, right, the precedent, because we got that now at page 45 of volume 3G. That's where, because that's the 1920 Act as amended. And there's a footnote that, that section 13 of the erstwhile Act was amended by section 10 of the 1951 Act so that the President of India became the visitor.
And that would be, my lord,
If you're not lordship looks at page
Of,
of this, PG, give some clarity. The Governor General shall be the Lord Rector of the University. And that's,
that's,
so the Governor General became the President, and the Lord Rector became the Visitor. That's what. Hope that's clear.
That is in 10, my lord. That rector became visitor.
That's how.
To define the
Yeah.
word.
65 Act.
Visitor.
The concept PDF.
Now the President is the Visitor as the Act is on today, as on today. That's at page 45 of the same volume. Now the President shall be the Visitor of the University. That's 13.
General got substituted for President, T1 Act,
Correct.
and when the, with the Constitution itself, and 51 Act says Lord Rector will be now read as Visitor.
That's correct.
So the circle is complete.
Then now the Visitor is the President. That's how it is.
Because we substituted Lord Rector with Visitor, the President becomes Victor.
the
Well,
president
the
should be the
visitor.
visitor of the.
This is PDF. Which Right. Now, my lord, the 65 Act, your lordship will find in the same volume at 99. The important section here, my lord, is section 2, my lord, which changed section 23.
Where do we get the 65 Act now?
My lord, PDF 99.
Of this, of volume?
4A, my lord, same volume.
Yes.
Vice Chancellor shall be omitted. Well, I'm taking your lordships to section 2 of that 23 is substituted. And the important, my lord, section is, my lord, B. For subsections 2 and 3, the functions of the court shall be to advise the visitor in respect of any matter which may be referred to the court for advice, to advise any other authority in respect of any matter which may be referred to the court for advice, to perform such other functions, such other duties, and exercise such powers as may be assigned to the visitor. So, my lord, it becomes an advisory body. That is the big change that is made. Our submission, my lord, on this would be, once you have decided the question of established by a statute, then everything else, my lord. But had that not been decided, that part of the statute part, these should have been struck down, my lord. Because they're quite clearly invasive. But of course, this is the precursor to this was,
Mr. Dhawan, then you are accepting that post these amendments, there was a change in administration
yes,
and the minority role as far as administration is concerned by these amendments was diluted. I'm using a,
I'm still on de jure. We come to different.
that's something separate. De
Yeah.
jure, it was certainly diluted, if not withdrawn.
What I'm saying,
When
what
you
I'm
argue
saying,
and say it should be struck down, you're accepting that.
my lord, what I'm saying is, my lord, had the Ajiz Bhasha, the ratio of Ajiz Bhasha is statutory intervention removes the. Had that not been decided and had they gone into these questions, these invasive provisions would have been struck down. That's what I'm saying. And of course, there is a restoration, my lord, where I'll just come to.
But Dr. Dhawan, now we are operating today 65 amendment has been made 35 and now 24, that is 59, 60 years ago. Do we strike down that amendment after the lapse of 60 years?
No, no, I'm saying you could not have struck it down because of the alternative ratio.
Basha said it was not established by a Muslim minority
Because
because
of
it
the
was
statute.
established by statute.
Statutory intervention.
Once establishment goes away for
Yeah.
Basha, it says it's not an MEI institution.
No, that's right, man.
Right.
I'm only saying.
But what you are saying is
Had the-
Basha
if your lordship were to hold
it is
that the
established.
statutory intervention part of Bhasha is incorrect, then some of these provisions are invasive.
So which means we'll have to strike them down today.
No, no,
To uphold their
not,
argument.
I'm not merely making
Dr. Dhawan, I'll tell you why. Unless we strike down those provisions now, these provisions still operate on the statute book.
Of course they do.
Yes, of course, because even only changes the preamble and
Exactly, by
Amended in 81 and the old position is restored, please.
1 second. Bol do. I accept your intervention.
What's the, all.
Just what,
My lord, I'm not asking your lordship to strike it down now, my lord. I'm just saying
we recorded
that this
that.
is a logical consequence.
We record that submission on behalf. And when we were arguing for the first, that you're not asking for striking down of 1951
Right.
and 65.
I'm saying it would have been an alternative had the ratio been confined to establish.
No, but even if we say that in your, let's assume everything in your favor, that we hold that Basha is wrongly decided.
On question of establishment.
Yes,
Even so, on the question of establishment,
yes.
right? Even so, the amendments which are made in 65, they don't get obliterated from the statute book merely because we say that Basha is wrong. Because that's an independent exercise of Parliament's legislative power.
Yeah, fair enough.
So we will have to say therefore, now look at the problem in our part. We will have to then say that because Basha is wrongly decided on establishment, there was a challenge to the constitutional validity of the 1951 and 1965 amendment before
It wasn't
Basha,
decided.
which was not decided. Now we have to decide it today in the absence of really any challenge before us. If we don't decide it, as we cannot after 65 years, that means those amendments of 1951 and 65 continue to hold the field today.
so that is what.
My lord, the point is, my lord, I'm sorry.
In that, even if we accept that in 1981,
So 81 they go.
some restoration, partial or full.
Not some, my lord, a radical.
Okay, partial or full, I say.
Yes,
That's something separate. But from 1965 or from 1965 to 81, it was not a minority institution.
my lord, I've said that. There are problems in that particular phase. I've indicated that. But, my lord,
Can that be then restored?
my lord, for that period, of course, your lordship will look at the de facto argument, my lord, but at this point in time, the reason why I put it in phases, my lord, was precisely because apart from this glitch that existed in 65, I've mentioned that the restoration then comes in 81, which I'll just show to you.
So your argument is because of the restoration, it came back.
That's right.
De jure argument.
Banatwala inquiry in 72 itself. will show-
And my lord, your lordship will bear one thing in mind.
And significantly, the 81 amendment, when in Parliament, this question is specifically raised, that you have merely done a facial amendment by saying established and deleting established and changing the definition of university. But you have not done anything to change the basis in the sense that you have not amended,
My lord, I'll
you have
take
not
your
changed
lordship
the
to 81.
administrative provisions.
My lord,
That's what Banatwala said,
three
Brother Dipankar said.
provisions, my lord, are facial in nature. That's the preamble, my lord, 2L and 52C. Assume, my lord, that they're not there. The rest of the 81 Act, my lord, also makes restorative provisions, which I'll show to your lordship.
So 65 law, the Act of 65 continues to hold the field between 1965 and 1981.
My lord,
71.
72 Parliament brings another.
Now let's see the 72 amendment. We have seen now the 65 Act.
we've shown the 65 Act.
65, anything apart from this that we have to see?
72, I've already indicated to your lordships, my lord.
70. Oh. 65, everything.
My lord, just kindly come to PDF 107.
That's the 72 amendment.
Matika.
Expect minutes.
I think our arguments about the court.
This is temp-
Page 102.
20 of the interesting one.
Why? $502.
By the 1965 Act, look at also the amendment to Statute 8 at page 102 of volume 4A.
Correct. Kindly look at that. That's not in the chart of the Solicitor General.
No, that's right. Let's see that. Statute 8.
Section that 8. The court shall consist of the following members: the Chancellor, the Pro-Chancellor, members of the Executive Council, key persons being.
Which page are you?
Page 102. This is very important. Huh?
It's very important. Worship had that?
Yes.
Says the court shall consist of the following members: Chancellor, ex officio, Pro-Chancellor, ex officio, members of the Executive Council, ex officio, 3 persons being heads of department of studies or principals of college of the university nominated by the visitor. Now, as your lordship knows, the visitor is the president. 2 persons being professors from departments of studies or colleges of the university nominated by the visitor. 2 persons from among teachers of the university other than the professors nominated by the visitor. 3 representatives of parliament, 2 of them nominated by the Speaker of the House of the people from among the members thereof, and one to be nominated by the chairman of the council of states from among the members thereof, and 30 persons nominated by the visitor. So the whole basis was changed. Now kindly come, there's another element your lordships must look at. Everything, yes, it's taken over. Now kindly look at they changed the executive council. Kindly look at page 103.
That's for statute 15.
Yeah. Now see 103. Statute 15. The executive council shall consist of the following: the vice chancellor,
Who's nominated?
7 persons nominated by the visitor, and 1 person nominated by the chief rector at his discretion. And all the members of the executive council other than ex officio members shall hold office for a term of 3 years. So the whole institution was taken over. Now Pasha doesn't decide that, because Pasha says, well, not established, so that's the end of the matter. That's what happened. But I'll address your lordships differently on this. This also is not provided by the solicitor in his lecture.
Then says, every person who was a member of the court shall, on the 20th of May 1965, cease to hold office.
Yes.
Take note of completely.
That is at page 105.
This situation, 65.
We have completed the 1965 Act.
The position is partly restored in 72 and fully in 81. That's what happened. Sorry.
Let's see the 72 Act now.
My lord, 107.
Volume 4C, right? 4A, page 70. Page 107. Chalo dekhte hain.
My lord, I want to refer to one part of the SOR, my lord, because Mr. Chagla, my lord, had mentioned that 65 was a temporary measure because there was a lot of agitation, etc. This is reinforced in the SOR, in the prefatory note, my lord, in 72. I'm on page 107. For it, you said, how many times do you have to say it? May I read that prefatory note, my lord? Because that is a declaration of Parliament on what 65 in fact did and in what context it did. It passed the 65 Act. May I just read it, my lord?
Yes.
Now, my lord. Prefatory note, my lord, statement of objects and reasons. as a result of disturbances that took place in Aligarh Muslim University, the president promulgated, just change it. What am I reading? Aligarh Muslim University Ordinance 65, and on 20th of May 65, the amendment came into play. The ordinance was later replaced by the Act of 65. Both the ordinances and the Amendment Act were temporary provisions to tide over the difficult situation which was prevalent in the university at that time, and the intention was to bring before Parliament in due course a comprehensive long-term legislation. And then it says why it could not be introduced. So this is a statement by Parliament itself.
Dr. Dhawan is very important, that the Justice Gajendra Gadkar committee was appointed.
That's right.
By the UGC. Everything was deferred until the report of the Gajendra Gadkar committee was appointed. Now see para 2 and para 5, they say that the recommendations of the Gajendra Gadkar committee are received, and the Gajendra Gadkar committee has proposed that all central universities should be brought at par. And in pursuance to which this is amended. So then this idea is to make this at par with central universities appears. See para 5, the report of the Gajendra Gadkar committee on governance of universities was received by government in July 71. Recommendations of the committee were accepted both by UGC and government in principle. It was also decided to amend the acts of central universities in the light of the recommendations made by the committee, based on the recommendation of the committee and taking into account all other cells. In fact, as government decided to introduce this comprehensive legislation for Aligarh Muslim University.
Yes, that's right.
Preface also the
And
last.
para 2 as well.
In prefacing the last line.
It was government that the report of the committee should be awaited before introducing long-term legislation for Banaras Hindu University as well as Aligarh Muslim University. And the second sentence, the intent all along was that the legislation for BHU and AMU should be broadly on similar lines.
But what happened, my lord, is Basha had come by that time.
Really speaking, they say in paragraph 3 that they were anxious to have a democratic setup because there was a Golden Jubilee celebrations in December 1970.
Para 2 on par.
And therefore, the Amendment Act of 1970 was introduced.
Lord,
But the bill got defeated there.
65 has an intention to bring on par. I'm not saying it didn't. But at the same time, 72, at the same time, my lord, the more comprehensive changes were made in the 81 Act. Because the report hadn't come, all those things were not done. And then I'll take your lordship. Now, my lord, let me just read from the SOR, my lord, the main features of the bill.
Yes.
The main features of the bill are, this is in 108, my lord. The university is being given additional powers. Important among them are provision of instruction through corresponding courses, establishment of special centers, specialized laboratories, and such other units for research and education as are necessary, and for further the objects of the university within a radius of 25 kilometers of the university, and appointment of persons working in other universities, institutions, or organizations as teachers. In view of the persistent demand for preserving the residential character of the university, the provision in the Act of the university for affiliation is being deleted. So, earlier, my lord, the affiliation to Allahabad, and now is being deleted. Then, my lord, it goes on to say, sub-Roman 4, the constitution and functions of the court, executive council, and other authorities of the university are being revised in the light of the recommendations made by the Gajendra Gadkar committee. The court will thereafter be a deliberative body and will not be saddled with the authority to overrule the decisions of the executive council and other bodies. And then, my lord, Further down, the court will consist of 104 members at this point in time.
Yes.
Just kindly come to 110, my lord. And clause 9 now.
Amendment 4.
Amendment 7.
Section 4 of the Amendment Act.
I don't see it here.
Section
Just mark the bloody thing here.
Section 4, Your Honor. Section 4, 7, clause
7, yeah. My lord, section 4, sub-Roman 7, my lord. For clause 9, the following clauses shall be substituted, namely to institute and maintain within a radius of 25 kilometers of the university mosque, hills, halls and residences, and to recognize places of residences for the students of the university within the said limits, and to withdraw such recognition according to any such place of residence. And then, my lord, clause 9, 9A, to establish within a radius of 25 kilometers of the university mosque such special centers, specialized laboratories for research and instruction in the opinion of the university necessary for furthering its objects. So those provisions, my lord, of 25 kilometers, which are part of the functions, my lord, of the university and show continuity, my lord, they will remain. Of the mosque, yeah. So, my lord, this is an interim measure which was substantially changed in 81. May I take your lordships to the 81 Act, my lord?
Before that, now what another very important thing it does is that it says that the chancellor will be now appointed by the visitor according to the statutes. The pro-chancellor and the vice-chancellor will be appointed by the visitor by statute, and the statutes are now provided in the first schedule under section 28.
Yes.
See, because section 28 says, section 28 is amended, section 24 of this act, page 115, on and from the commencement of the Amendment Act of 1972, the statutes as set out in the schedule shall be the statutes of the university. Now let's go to the schedule and see what the schedule does.
Schedule? No, we'll come to the 81 Act. 119, my lord.
119. Now see what this does. Look at the amended statutes, page 119.
Yes, sir.
Now the modalities for the appointment of the chancellor is that the chancellor shall be appointed by the visitor from a panel of not less than 3 persons recommended by the executive council.
Yes, sir.
So really the appointment of the head is now vested in the visitor completely.
It is, my lord. That part has not been changed. We will only see the changes now, my lord, in the 81 Act.
It does not agree with the panel.
Because at that stage, my lord, Bhasha treated it as a non-minority institution. And these were consequential changes following Bhasha.
Now, statute 14 is substituted at page 125. So the court. Now, see who is in the court. Court now becomes vice-chancellor, ex-vice-chancellors, pro-vice-chancellor, deans of faculties, students' council, students' welfare, librarian, representatives, principals of each of the following colleges, namely Women's College, Tibia College, and Polytechnic by rotation, heads of department, 5 professors, representatives of students, representatives of ex-students, representatives of parliament, members of the learned professions, nominated members, remaining members. So would it be correct to say that, by the 1972 Act and the statutes which are substituted, the Muslim character of the institution as it existed in 1951 and following the 1965 Act, because 72 Act has never been in challenge.
They've never been, that's true.
And this now becomes completely a secular management, isn't it? See what happens to the Executive Council, for instance.
My lord, we have to come to 81, my lord, to see those changes because they are the definitive ones.
So we'll
More democratic.
because, we will now have to see finally, what did 81 do? What was restored under 81 and what was not restored under?
Let me come to that.
Yes.
148. 140. वो इसमें वो कहाँ है SOR ठीक है May I just read, my lord? My lord, the prefatory note, my lord, in 148 says, the SOR, India is a multi-religious country and its strength lies in the fact that all communities living in the country are free to establish educational and other institutions of their choice. The government have introduced in Parliament an amendment bill to remove the doubts in the mind of the Muslim community regards the character of the Muslim university, but the amendment of the Muslim University Act would be meaningless and would become redundant if the statutes are not amended to satisfy the sentiments of the Muslim community. Therefore, my lord, it is therefore necessary to introduce a bill in the Parliament to achieve these objects. That is the purpose, my lord, in the SOR. Now, my lord, subsection 2, my lord, says, in the Aligarh Muslim University Act 1920, herein referred to as the Principal Act in the long title and in the preamble, the words establish and shall be omitted. This was struck down, my lord, by the Allahabad High Court. Then, my lord, if your lordships will come to section 3, that is L, my lord. University means the educational institution of their choice established by the Muslims of India, which originated as the Mohammedan Anglo-Oriental College, Aligarh, and which was subsequently incorporated as the Aligarh Muslim University. And this was struck down as well. Then, my lord, kindly see section 4, which amends 5. 5.1, my lord, to promote specially the educational and cultural advancement of the Muslims of India. Your lordship has seen that?
No.
That was also struck down.
What was struck down was that.
Now, my lord, I want to take your lordships to the other provisions that are important. Section 12, my lord, was not challenged. The court shall consist of the Chancellor, Pro-Chancellor, Vice-Chancellor, and Pro-Vice-Chancellor, if any, for the time being, and such persons as may be specified in the statutes. This is also a restoration, my lord, of the earlier provisions. Then, my lords, I need to, subsection 2. The court shall be the supreme governing body of the university and shall exercise all the powers of the university not otherwise provided by the Act, statutes, ordinances, and regulations. And it shall have the power to review the acts of the executive and academic councils, save where such councils have acted in accordance with the provisions. Then, my lord, the powers are given in subsection 3. I think I've got it here. Subject to the provisions of this Act, the court shall exercise the following powers. These are the provisions, my lord, that empower the court once again to make statutes and to amend or repeal the same, to consider ordinances, to consider and pass resolutions of the annual report, annual accounts, and the financial estimates, to elect such persons to serve on the authorities of the university, and to appoint such officers as may be prescribed by the Act. And then, my lord, E, to exercise such powers and perform such duties as may be confirmed or imposed by it by the Act or the statutes.
To take it. Which powers is it?
So, my lord, many of the provisions that were there in the original Act, my lord, have come back. And I'm not dealing, my lord, with the... And none of these, my lord, I had argued the case, my lord, before the Allahabad High Court. None of them were challenged.
Just section 7.
I want my learned friend, it's important, my lord, section 7, my lord. In section 17 of the Principal Act, the following subsection will be substituted. The Chancellor of the University shall be elected by the court in such manner and for such terms as may be prescribed. So, here the Chancellor is now elected by the court. As your lordships will see, the Pro-Chancellor will also be elected. The Pro-Chancellor shall be elected by the court in such manner, same thing. Then, my lord, in the Principal Act, the Treasurer, my lord, your lordships will see what is introduced here in 20 capital A. The Honorary Treasurer shall be elected by the court in such manner it's. Then, my lord, if your lordships will come to 12. No, 20 Finance Commission, etc. 12. Substitution of a new section for section 23. This is section 12. None of this is challenged, my lord. The only challenges were made with the 3 provisions that were struck down. The court shall consist of the Chancellor, Pro-Chancellor, Vice-Chancellor, or the Pro-Vice-Chancellor, if any for the time being, and such other persons as may be specified in the statutes. Then, my lord, subsection 2, the court shall be the supreme governing body of the university and shall exercise the powers of the university not otherwise provided by the Act, etc. Then, my lord, the duties are mentioned in subsection 3. Subject to the provisions of this Act, the court shall exercise the following powers and perform the following duties. This is the court again to make statutes, to amend or repeal the same, to consider ordinances, to consider and pass resolutions on the annual report, to elect such persons to serve on the authorities as may be prescribed. Anything else here? We go to the statutes. 16, my lord. There's another substitution. On the commencement of the Aligarh Muslim University Amendment Act, the statutes in force immediately before such commencement as amended by the Act shall be statutes of the university. And then, my lord, after the commencement of the AMU Act 1981, the court may, notwithstanding anything contained in subsection 1, make new or additional statutes or may amend or repeal the statutes referred to in subsection 1 in the manner provided. Now, my lord, come to section 3, subsection 3. The Executive Council may propose to the court the draft of any statute for its consideration, and such draft shall be considered by the court at its next meeting, provided the Executive Council shall not propose the draft of any statute or the amendment affecting the status, powers, or constitution of any authority, unless until such authority has been given an opportunity to express those are natural justice provisions. Now, my lords, page 152, section 35, my lord. 21 seconds. 20 is not important. 21. Throughout the statutes, head of department, wherever they occur, will be the chairman of the department, shall be substituted, and such consequential amendments made in the rules of grammar that may require to be made. Then the chancellor shall be elected by the court by a simple majority. The chancellor, that's 3 years, we're not concerned with that, my lord. Pro-chancellor is also, my lord, elected by a simple majority. What are you proposing?
The proviso removing the Muslim character, my lords, that is not restored. That's not restored.
May I complete? I'm racing against time. You didn't have that disadvantage. What do you want to write?
The Vice Chancellor, the appointment of the Vice Chancellor also.
Then, my lord, in statute number 2,
By the West.
in one PDF 153, the Vice Chancellor shall be appointed by the visitor from a panel of 3 persons recommended by the court, from a panel of 5 persons recommended by the Executive Council, provided that if the visitor does not approve, he may call for fresh recommendations. So that is a process, my lord, that is important.
Then the whole.
Earlier it was visitor, now it's from the court to the visitor, my lord. Now, my lord, kindly come to the composition of the court in section 14, which had been deleted earlier. Chancellor, Pro-Chancellor, Vice-Chancellor, Pro-Vice-Chancellor, Honorary Treasurer, Treasurer, all ex-Vice-Chancellors, all Deans of faculties, Deans of Student Welfare, Librarian, Registrar, then 20 Chairmen of Departments. These are democratic, my lord, changes that take place to represent students. And then, my lord, your lordships will see on page 154, the representatives of the All India Muslim Education Conference, 5 representatives, representatives of Parliament, representatives, my lord, of Muslim culture and learning.
25 representative ex-students to be elected by
Right.
the Old Board Association. That's 20.
Then, my lord, kindly come to 25. Where are we? 15 persons representing Muslim culture and learning to be elected by the court, of whom 10 shall be persons residing outside the state of Uttar Pradesh. Next, my lord, that is 26, sub-Roman 26, 6 persons representing Muslim colleges of Oriental learning in India to be elected by the court. Then, my lord, chairman of Waqf boards, my lord, and to be elected by the court once again. 2 persons representing Urdu language and literature to be elected by the court. Then, my lord, 29, sub-Roman, 5 persons of Muslim and cultural societies situated outside the state of Uttar Pradesh to be elected by the court.
Muslim character.
Can we, my lord, argue that the Muslim character is not mentioned here?
It has been thrown out. That's what he said.
And the argument, my lord, on the other side was that the Muslims have been thrown out.
But he's challenged these provisions.
No challenge. Therefore, my lord, the 3 that were struck down are separate. Now we are looking at the administration, and which have not.
To look at is that in the court, look at the ex officio members. there is no requirement under the statute that they have to be professing the Muslim religion. So from clause 1 to clause 14 is agnostic to religion.
That's right. That's right.
Then likewise, actually from clause 1 to clause 20. 21, you get 10 representatives of donors who have donated at least a sum of 10,000 rupees. Then again, 10 persons representing learned professions to be elected by the court. 28 is certainly representatives of the All India Muslim Conference, 5. Then
Before
10
that,
members
Urdu
of
Malad.
Parliament, 10 members of Parliament. Again, there's no requirement of religion. So if you look at 23, 25, 26, 27, 28 and 29.
Yes.
These are the real Muslim representatives in the court.
Milord, there had to be a democratization. I know of no university, and I've taught in many, Milord. You have to bring the students in, you have to bring the eminent professors in. There is no other way to do it.
But can we say that now, as a matter of these amendments, de jure, that control is vested in the Muslim community by the court? Or is it that they also have a representation in the court? Would it not be more appropriate to say that now they've got a representation in the court, but they are not controlling the court, or there is no legal requirement of the proviso to section 23 that only a Muslim can be a member of the court? Because that which was deleted, the 23(2) proviso, that has never come back thereafter.
That is true, Milord. I'm not doubting that. But, Milord, the operative part in the judgment says in whom the minority have confidence.
Overwhelming majority can be
Milord, we're not.
What is the total strength of the court? In number broadly, it will vary. But it's all ex-vice chancellors. It depends on how many ex-vice chancellors are still.
All Muslims.
No, I'm not done that. What is the total number in the court?
About 180.
No, not ex-vice chancellors. Just the total number in the court.
180.
180.
And when you say vice,
out of that
vice
180,
chancellors,
out of that
you have to
180,
go into the de facto.
how many are drawn from clauses 23, 25, 26, 27, 28 and 29? We'll actually get it here.
About 40.
It will be
But
5.
we need, but Milord,
Five
when we
plus
say
20,
ex-vice chancellors, we need to add to that number.
32, 37,
40.
37.
So that makes it 65. There are 25 old boys.
There are 4 or 5 former.
Distinction between who has to be necessarily a Muslim.
They have to be.
But even 28
Part of
Old boys will
need not be
be
Muslim.
from other religion
Because there are
also.
a lot of
the constitutional issue is not a numerical issue, but I'll argue that. Nothing to do with the issue. We're going into numericals, which has nothing to do in the context of what is a minority institution. I come to that, or let my understand finish.
So, Milord, we've more or less done with this.
Done with the statute.
Now, Milord, can I take your lordships to my written submission? Just a small. Page 25, Milord, of my written submission.
There is a report of.
Volume 1F.
Whether your lordship would like to see now, Milord, or later on, Milord? Relevant portion of that, the committee report. We can show it later on.
No, you might as well tender it now, because, then they can also look at it at lunch if there's something of relevance in that, because you will not get any opportunity now after they've
It's
responded.
only the relevant pages, Milord, which you've taken out, and otherwise the whole of it will be.
There are so many reports in our favor. This
So this 72 Act which talked about that report.
There's a Charity Committee's report in 1961, which is entirely in our favor. Minority Commission report is in our favor.
Since you all were referring.
Ajay Karkar is in our favor.
all that, but ultimately, it is a constitutional issue. It's not a numerical issue.
No, the idea was to make it, to treat it as a central university.
Well, let me just in a minute tell your lordships, what the constitution committee.
What is this?
Did I establish this university once? If I establish, I have the right to administer. I have the right to establish and the right to administer. The test is not whether I'm administering or not.
It says that
We're going into something which is not relevant for the constitution at all.
What has been handed over?
And this has been held by 11 judges.
My Lord, I don't want to get into the question of the committees, my Lord. Because by and large, they are in our favor. Just to take out a paragraph or two will not make a difference, my Lord. If my learned friend, my Lord, wants to do the sur rejoinder now, the answer would be very different. I don't think so, my Lord, that we go into the committees.
Now, what is the next limb, Mr. Dr.
My Lord, I am just going to one or two provisions. My Lord, page 26,
Of volume?
1F. Here, my Lord, I won't, I go to 7.3, the de facto argument. Because the de facto argument becomes important. If, my Lord, the numbers that had been appointed were de facto Muslims, then we don't, my Lord, at that stage, in any way, my Lord, we're not in any way, I'm sorry.
Yes.
Lord, I'll leave it there, my Lord. Lord, I just want to read, I'm sorry. ये कमिटी में कहाँ पहुंच गए यार? An argument.
acceptable, but just do one.
कितना पढ़ेंगे यार ये?
University. From 20 it is centralized.
which is worrying us, we may tell you now, so you have a little time over lunch, is that the 1981 amendment does not restore the position as it stood prior to 1951. In other words, the 81 amendment does it does a half-hearted job. I can understand if the 81 amendment had said, okay, we are going back to the original 1920 statute, confer complete minority character on this. It says, okay, established we are changing, university we are changing the definition. So it was really they were placating that sentiment. But when it actually came to the brass tacks, they didn't go back to the position prior to 1950.
Well, in part.
And what it did was it brought a Muslim voice into AMU's administration, as we see it in the court, for instance. They brought a Muslim voice into the institution.
That's correct.
But it still stopped short. Even Parliament, which it had power to do, it still stopped short of taking us back to the 1920 Act or the pre-1951.
Take, for example, the foundation members.
Some or the other, they waddle.
Obviously,
and they said, okay, we'll do a little bit of, we'll make a few concessions, but they never took us back to the pre-1951 Act. That's something which,
to some extent, it couldn't have gone back. There were two elements, my lord. Firstly, the democratic elements of students, etc., were brought in. That is consistent with the fact that some democratic elements had to be brought in. We get a voice, my lord. Now, suppose, my lord, these were non-Muslims all across the back. They might be subject to challenge on the de facto argument.
All right, we'll come back after lunch.
I'll only take 5 minutes more, my lord.
Certainly.
And then I'll hand over to Mr.
Certainly. Thank you. Thank you, Dr.
I'll just take a few minutes.
Yes, Dr.
My Lord, in response to your Lordship's question earlier, my Lord, your Lordship indicated that the 81 Act may be half-hearted. I have, my Lord, two responses to that. The first is, my Lord, the numerical argument in the court. But, my Lord, we don't just have to look at the court. We have to look at the purposes of the university. And these are writ large. I'll read them out from the amended act, my Lord. The purposes your lordships will find in the original act, it said to promote Oriental and Islamic studies and give instruction in Muslim theology and religion and to impart moral and physical training. Now, what was added, my Lord, in 72 was to promote the study of religion, civilization, and culture of India, and C, which is important, my Lord, which comes in 81, to promote specially the educational and culture and advancement of Muslims in India. So I'm making a distinction, my Lord, with the powers and composition of the court on the one hand, and the purposes of the statute read as a whole. And it is the purposes of the statute that will govern. It's the purposes of the statute which will also run alongside. And that's it. We can't read the act minus the purposes of the statute. And then, my Lord, in Statute 20, there are various, my Lord, faculties and departments which are clearly to promote the Muslim culture. So this is the fundamental, my Lord, distinction that we wish to make. That you go by purpose, you go by empowerment. And to that extent, my Lord, the statute is crystal clear. The second point, my Lord, that I wanted to make draws on Justice, as he then was, Mukherjee's argument in the Bhopal case. And that it says, I'll give your lordship the citation, 1990, 1 SCC, 613, and para 13. He says we not just examine the provisions of a statute, but also how it works itself out. Now, the de facto de jure, my Lord, are not opposites. They are composites. Therefore, when we mention the de facto argument, it is how the act has worked itself out. And that is a consideration that your lordships will consider when your lordship examines how it works itself out. The rest, my Lord, Mr. Sibal will answer. Can I just take your lordships, my Lord, back to my submission? There are just 2 or 3 paragraphs, my Lord, that I have to read. That is 26 in volume 1A, 1F, yeah, right.
26.
7.3. Muslims have a de facto administrative control over AMU since its founding in 104 years. All members of the first council first court were Muslims. Then all the members of the first executive council were Muslims. 8 of the 12 members of the academic council were Muslims. Every chancellor to date has been a Muslim. 34 out of 37 vice chancellors. And then the vast majorities of the members of the court. 3 non-Muslims were acting vice chancellors. The vast majority of the members of the court, executive council, academic council, throughout the years have been Muslim in nature. Now, because I'm saying we have to examine how the act works itself out, de jure and de facto, my Lord, have to be considered together. Then, my lord, I come to the 7.4, notwithstanding the de facto and jure control, if any provision of the AMU Act is found to be invasive of the minority character, they will be susceptible to challenge. Then, my lord, 7.5 is an important point, and we've just put in the quotation from P.A. Inandar. It says that if 1906 restrictions are there which are invasive, then it is 30 that will trump 1906. And over the page, my lord, there is a distinction which I'd made earlier, which I'm reinforcing, between external supervisory control and internal day-to-day control. These are requirements after 1950 to conform to a more egalitarian constitutional setup. It does not denude the institution of its minority character. And then, my lord, apart from 67, well, to 81, AMU has always been a minority institution. And therefore, one of the questions was, why now? The question, answer to that question, my lord, is it's already been there throughout this particular period, except for this interim wait, which I described in the phases. I don't want to say more than that. I must yield to Mr. Simbal. My lord, I call him my guru from time to time. And Justice Thakur said, who is the guru and who is the shishya? We don't know. Let me end on that, my lord, by way of levity.
Thank you, Dr. Yes, Mr. Sibbal.
This matter has been argued at various levels. One, that this university was not established by the minority community, which is the finding in Basha. Then, Mallards, in any case, it was not administered by the Muslims. That's the other level. That's also the finding in Basha. Then, in any case, it is not a minority. That's the third level at which it was argued. And four, that it is an institution of national importance, so it's lost its minority character, even if it had any. These are the four broad submissions that have been made. And I think, Mullahs, with respect, greatest respect, that we are going a bit astray constitutionally. What does Article 30 say? All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Let's pause here a minute. If I have not established as a minority, I cannot administer. So I have a right to establish. That's what 30 says. If I have established, then I have a right to administer. So Article 30 gives me a right to administer. It doesn't say that the administration must be in my hands or in Muslim hands or Christian hands. That's not the meaning of Article 30. Administer of my choice, rise to administer of my choice. I have a choice, not you, not the government. But I must establish it. Unless I establish it, that right doesn't accrue to me. And the right that accrues to me is the right to administer the institution as I please, of my choice.
Well, let's take, for example, any minority institution in this country. Malad, I don't think any minority institution in this country is administered by minorities. You apply the wrong test, you'll get the wrong answer. Take St. Stephen's. How many teachers are minority? Not even 5%. Administration. How many are filled with Christians? Not more than 5%. Students. How many are Christians? I don't know now, but it used to be 9%, 14%. Well, what's the relevance of that? This whole numerical argument is only irrelevant to Article 30. So, let's kindly take the statute. Take St. Stephen's College in the context of Delhi University statute. The syndicate, I am not part of that syndicate. I'm not part of the executive council. I'm not part of the academic council. That means I'm not a minority institution. What tests are we applying? Never before in the history of this court have these tests ever been applied. That's why there are no judgments cited, Bharat. So, Malad, the mistake in Basha was that when Basha said that you have not established this university as a minority, then the council argued, but I am administering it. And Basha said, you're not. That's not the test. So Governor General does this, Rector does this, Malad. I want to ask myself a question. If I am enacted by an act of the Central Legislative Council, Malad, will there not be a structure by which somebody has to see that I'm not maladministering? Take our constitution today, I set up a minority institution, Malad. When I'm setting up that institution, will the chancellor of the institution, which has nothing to do with the minority, not have the right to inspect? He'll have the right to inspect. He'll have emergency provisions. He may even have the right to take over. Administration doesn't mean maladministration. So let's start with the proposition that I have a right to administer. Your Lordship asked a very fundamental question, but the 81 Act is not a status quo ante. Your Lordship is right, but I accept it. I accept it. I'm not a minority institution. I still am. That's my choice. And that's the other mistake that we are making, which is an error of law. I don't have to be administered either by the Muslims or the Christians when it comes to minority institutions. You won't have Christians or you won't have Muslims, Mullahs, who are educated at that level to be in every. So, Mullahs, TMA Pi had 4 tests. Para 50 of TMA Pi set up 4 tests. What do you mean by administer? Mullahs, just kindly come. I've done a rejoinder, Mullahs. It's also part of the kindly come to note 1G. Yes. Page 3 of note 1G. That's why, Mullahs, my learned friends, when I argued this in the beginning, never answered that question. Because 1906 regulates minority institutions as much as it does majority institutions. Regulation does not mean destruction of the right. So if the chancellor is appointed, Mullahs, by the president, it doesn't mean that I've lost my right as a minority institution. So let's kindly see the TMA Pi para 50.
Where do you get it?
Well, that's my volume 1G, Malat.
At page?
Page 3.
Yeah.
Ambit of right to administer was set out as including the right to admit students, subject to an objective and rational procedure of selection. No problem. That's the institution as the right. The minority, once I establish the institution as a minority institution, I have a right to admit students in accordance with procedure which is fair and transparent. Perfectly good. I'm doing that in Jamia, in AMU. 2, set up a reasonable fee structure. The institution is doing it. 3, to constitute a governing body. We have a governing body. It doesn't say governing body, we must have all Muslims, or governing body, we must have all Christians. Where is it said? Where is that test? 4, to appoint staff. Appoint staff. Normalists. The university says, if you want to teach in AICTE, the teacher must have these qualifications. They abide by that. But the right to choose the teacher is mine. In Delhi University, the university provides that if you want to teach economics, the person must be a doctorate or whatever. The choice of which doctorate will teach is mine. But the university will set the standard. That's what it is, to appoint staff, teaching and non-teaching. Standards set by the institute, by the structure of the university. And 4, to take action if there is dereliction of duty. These are the 5 indicia of administration. That's 11 judges. Now test this in the context of what Basha said. Now kindly come to Basha for a minute. 3A. Yes.
Is to establish and against.
Yeah, I know. In page 16. Yes. I'm sorry, page 16 of Basha at volume 3A, page 16. Animals pracetum GNH. Wrong argument, therefore the wrong answer. It's not a twin test. Am I administering? That's not the test. And we have all, Maharaj, throughout these days, we've been arguing about, show me if you're administering. It's not required by 30. You'll never get that, Maharaj. That way, there will be no minority institutions left in this country. Apply this to even to the institutions after 2005. All the provisions that are here in the 81 Act are all there in 2005. Inspection, emergency, a final approval, all that. I've got a chart, I'll show it to you. So what are we trying to do? Apply a test which will destroy the entire minority structure, Maharaj, of education in this country?
They don't read.
That's why, Maharaj, if your lordships remember, in the opening I said, and your lordships put it also, that your argument is that if I cede that right, that's my choice. To the extent that I cede it. If I feel somebody is interfering, I can challenge it. I can challenge it. I have a right to administer, not a duty that I must administer everything. And no judgment of any court since, Maharaj, 1950 has held this. That's why I got up and said that numerical strength is not an issue, can never be. I am satisfied with this, Maharaj, and I will go numerically also. Out of the external members, Maharaj, I am 77 out of 104. But, I don't want to fall into that trap. That's why I choose not to challenge. I'm happy. So this is the fundamental constitutional issue that your lordships will have to decide, and consistent with judgments of this court. It's not a twin test. I have the right to establish, I have the right to administer, and of my choice. So, Maharaj, if I am within Delhi University, I am an affiliated college, I accept the discipline of the university. So what is the only choice I have in St. Stephen's? Some element of reservation. That's all, nothing more. And I appoint my own teachers, I dismiss my own staff, I take disciplinary action against him. I have an admissions policy, which now, Maharaj, I don't want to talk about it. That's pending in this court. I had an admissions policy where I could admit students, but with standards. Your lordship knows in private institutions also, those standards had to be applied. You can admit. The Christian Medical College, Maharaj, your lordship knows, they used to hold their own tests at one time. And they had their own standards. The court said, no, when you come to medical seats, you should go by NEET. Fine. That doesn't mean it's not a minority institution.
Mr. Subbal, one clarification.
Yeah.
Just please see one head note above paragraph 48 in TMFI and just clarify, para 50 applies to minority government aided.
Yes, I'm on government aided.
Just clarify that part.
Yes, I'm government aided.
No, you are government aided, but see the head note above para 48.
Private, unaided, non-minority educational institutions. That is the head.
That applies also to government aided. That also applies to government. It makes no difference.
What page is it?
It's all right, non-minority. Same principle applies. Same principle. We are talking about administration. Well, please appreciate. We're talking about administration, nothing to do with minority, non-minority.
50.
I said the test of administration.
So whether the same test would apply for a minority.
It will have to, under 30, it will have to, Maharaj. Your lordships have never said otherwise.
Somewhere provided as to what would be the test for minority. Because this is specifically dealing with private, unaided, non-minority.
Because the argument was that we should not be subject to anything. Maharaj, I am on, please appreciate. Let's test it on first principles. The meaning of administration can't change, Maharaj. Let's test it on first principles, Maharaj. Let's test it on first principles. What does administration mean? Whether it's minority or non-minority makes no difference. Administration can't vary if an institution is aided or unaided. a minority or non-minority. The meaning of administration can't change unless you find it in section 30 that not only do I have the right, but I must administer the institution all by myself.
Mr. Sibal, your argument being,
Well, para 5 only explains what the right comprises, or 50 only explains what.
It says to admit students.
Yeah.
Therefore, a private institution may say that I will admit only a particular category of students, students belonging to a particular category. It's a private institution.
Can't say. Can't say. If it wants a degree, it cannot. Well, I'm sorry.
No. This is only institution. TMAPI was not concerned with university.
No, it was considered, we're dealing with everything, schools, universities, institutions, everything. Well, let's pause here. I am a non-minority unaided institution, but I want a degree. I'll have to abide by the admissions policy. But I can, within that, admit students of my choice on merit. See, let's talk of first principles here. The right to administer cannot
Can you
change.
say that in a particular course,
Yes.
100% would be from a particular category?
Cannot be.
Can you say, you can't do that?
You can't.
Can you say that 50% would be from a particular category?
In minorities, yes. That's the law. Yes, that's the law. Within minority institutions, yes. And merit. We can't do away with merit. But that doesn't mean that I've lost my character or I have surrendered. Therefore, let's be clear on first principles here.
No, because in 2004, for the first time, you sought to reserve 50% for the PG course. Prior to that, you did not.
I tell you, Lordship, why? Because I'll come to that later. The area of maneuverability, as I was concerned, had been reduced from 50 to 25%. So therefore, I wanted. And it was struck down, according to me, maybe rightly, but that we're not on that. At the moment, Millers, we are discussing the fundamentals of Article 30. Where do you get this proposition that a minority institution for the Muslim community must be administered only by the Muslim community? Not in Article 30, not in any judgment of this court, not even in TMAPI. And this is the proposition that Barsha Mullahs proceeds on. Look at the rector, look at the Governor General, he is not a Muslim. Well, that's the argument. Does the President of India have to be a Muslim to get St. Stephen's minority status? What kind of argument is that?
Establishment of the institution.
Yes. Which page? Well, if this were the test, there'll be no institution, Mullahs, which can never claim to be a minority institution in this country.
argument is, as if a minority establishes an institution, that's good enough for compliance, for getting protection.
Yes, under 30.
Under 30.
Correct.
It's my right, therefore, it's my right to administer, and my right to administer includes these 4 points.
Correct. You may expand it, Mullah, I have no problems with that. But the right to administer is my choice. I can give up certain rights. I can't waive a fundamental right, as your lordship knows. But I can give it up for the time being. If I find still interference, I can challenge it. I can choose not to challenge. So St. Stephen says, Mullah, I just read that. It says the right, exactly what my lord has said. The right claimed by a minority community to administer the educational institution depends upon the proof of establishment of the institution. The proof of establishment of the institution is thus a condition precedent for claiming the right to administer the institution. That's exactly what my lord said. And Basha also says that. But Basha says, but you are not governed by Muslims. In fact, Basha should never have gone into this question. If Basha came to the conclusion that that this is not established by a Muslim minority, there was nothing to, it should have stopped there. Why it didn't stop? Because we made the argument, even if we are not established, we are administering the institution. It's a mistake on our part. It's for the first time, my learned friend is agreeing with me on this. And university was not a party. No,
My learned friend is in rejoinder. There are several statements which are either inaccurate or misleading.
Mullah, I'm
But
sure
we won't
my
have
learned friend is my learned friend is very kind always to say that everything that I say is misleading the court.
Not everything.
And the politeness of my learned friend with which you say it is admired by me.
Not everything. I didn't.
Well, what is it that is misleading? Make one statement that is misleading. One statement. Don't just get up only for the sake of getting up.
Mr. Sibal, what is the meaning of para 54 of St. Stephen?
54. Volume 5, yes. 5A, yes. Para 54. Which page is that? Page 422.
St. Stephen's is page 4.
22, my lord.
Para 54.
422.
5A, page 422.
Yes. That's exactly the point.
Particularly the line,
Yes.
this management must be free from control.
Correct. Or the founder or their nominees can mold the institution as they think fit and in accordance with their ideas of how the interests of the community in general and the institution in particular must best be served. Entirely in agreement with what I'm saying? Entirely. That's my choice. Supposing, Malad, the Vice Chancellor of Delhi University said, I will appoint your teachers. I will decide who will teach in the university. It will be violative of 30. And see, read the rest of the paragraphs. It's all in my favor, Malad. But the standards of education.
Funds, as you like.
I'm sorry?
Whatever public funds you receive,
Yes.
can you use it as you like?
No, Mullah, I'm grant in aid. 90% Mullah's grant in aid is given to me. That's and TMA Pi says the fact that you're aided has nothing to do with the minority character of the institution. You still retain the minority character. Aid is fundamental.
No, the
duty.
fact that your accounts are audited by the CAG,
It's audited.
does it not make any difference?
No, because it must be audited. I am not absolved of the general principles of law applicable, Mullah. That's nothing to do with administration. Mullah, it's to prevent mismanagement, to prevent maladministration. That's why, Mullah, it is to be audited.
Page 416.
1 second, hold on, sir, if you don't mind. Allow me, I don't interfere like this, please. Allow me.
That was not right, but I leave it.
I'm sure.
Very good.
Please leave it at that.
Please.
Yes.
There are 36. They do have the number test.
Again, do have the number test means what?
416.
You'll find out what it means.
Reading the paragraph. This only establishment of the institution, nothing to do with the administration. Again, you are misleading.
The management.
1 second. This is how the institution is established. Bishop of the diocese, who shall be the chairman. The persons appointed by the bishop of the diocese.
Says management.
He is not managing the institution. This is the genesis of the institution. The North, but let's not have I'm before the court, not before you. The day you become a judge, I'll argue before you.
Come on now, let's.
Anyway, let's not deviate from the issue.
But that means 36 does help me.
1 second.
Sir. Justifies that 36 does talk of management, does talk of administration.
I don't understand what my learned friend is unnecessarily. But I don't know why. Keep on.
All right, yes, Mr. Sibal. Yes, we now go virtually the end of the arguments. Yes.
No, it's not the end, Mulad. It happens to be just the beginning of my argument.
You've got 1 hour and 15 minutes.
I can't possibly finish, Mulad.
We close today. We have another matter listed next week. Today,
it's impossible to.
We don't mind continuing beyond 4 o'clock, but Mr. Sibal, we have to.
I have not raised any new point. I'm just trying to answer.
No, but this point which you have made, that it's your right to establish, it's your right to administer. And merely because you choose any third party to administer doesn't take away your right to administer in a manner which you think is appropriate. That's the point.
That's the point. That's the point,
It's a
Mulad.
right and not a condition.
Yeah,
Qualification.
that's correct. That's all, Mulad. It's not a right, not a condition, Mulad. Absolutely right. Not a directive, not a condition, not a directive, St. Stephen says so. So, Mulad, having said that, Mulad, now see what mistake Basha made. Okay. 16. Volume 3A, page 16, Mulad. Okay. Page 16, placitum G and H, Mulad. An argument has been raised, Mulad. Might just have that. What's the time? Okay.
1-7.
Placitum G, Mulad, at page 16, volume 3A. Plus TMA pi answers the question of aid. TMA pi answers the question of affiliation. None of these conditions, Mulad, can take away from the character of the minority institution. So that, Mulad, is already covered by this judgment of 11 judges. But Mulad, kindly see, if your lordships don't mind, Mulad, placitum G, paragraph 3A, at page 16 of Mulad, volume 3A, Basha, Mulad, volume 3A, page 16, between placitum G and H.
Age Basha is right.
It's consistent with St. Stephen. That's what I'm saying, Mulad. I'm saying exactly that. But then what does Basha say? Kindly see the other paragraph. Page 17. Between E and F, Mulad, you see the two words in Article 30 must be read together. And so read, the article gives the right to a minority to administer institutions established by it. If the education institution has not been established by a minority, it cannot claim the right to administer under 30. Perfectly good. Then, Mulad, what does the argument? We have therefore to consider, to examine closely what happened in 1920 when the Act was passed to decide whether in the face of the Act it could be said that Aligarh was established by the minority, whether the right to administer it ever vested in the minority. That's the wrong thing. This is ultimately the conclusion. I'm sorry. was the other passage which says, no, that it at page 22, in paragraph F, nor do we think that the provisions of the Act can bear out the contention that it was a Muslim minority which was administering the Aligarh University. Well, this is wholly irrelevant. That's not the test. The issue is not whether the Muslim minority were administering the university. Already, Malaz, the Basha said, if you've established it, you have a right to administer.
But then why did you challenge the 1951 and 1965 amendments?
I'm sorry?
Why were you mean the sense, why was the 1951 and 1965 amendments challenged in the first place?
Because it took away my right to administer.
Right. Therefore, that's exactly the point. So the 1951 and 1965 amendments were challenged.
I did not challenge, but somebody challenged.
Right. AMU didn't challenge.
Yes.
It was challenged on the ground that both these amendments took away the right to administer.
Yes.
How did it take away the right to administer? By creating institutions for the governance of the university in which people who are not of the faith or of the confidence of the founders would be brought in. That was the essence of the challenge. Otherwise, if your argument today is right, that once you have established, you are entitled to decide how to administer, then there was no reason to challenge the 51 and the 65 amendments.
With respect, there is a reason, Malaz. The reason was they took over the entire control of the university. I was under Basha, not a minority institution.
Therefore,
I was not a minority institution under Basha.
Taking away, how did they take away the control of the university? They took away the control by, for instance, regulating. First, it said that the proviso to 23 was deleted. Secondly, the constitution of the court was altered.
Correct.
Then they brought in the concept of a visitor. They brought in a whole lot of other changes. Now, that was alleged to be, that was challenged on the ground that it takes away the right to administer.
Correct.
Now, if that be so, if 81 is not under challenge.
No.
Now, if 81 does not restore the position as it stood entirely prior to 1951,
yes.
Then the amendment which is not in challenge has not, though it purported to do that, it has not in fact restored the position prior to 1951.
I agree, Malaz. I'm happy with 81. I have no problem with 81.
That's exactly, but you can't be happy with 81.
Why?
81 doesn't go far enough.
No, it's far enough for me, Malaz. Please appreciate what I'm saying. It is far enough for me. I am 74 out of 104 in the external members. The court is restored. My voice is heard. The Old Boys Association are represented.
But
I'm happy with that.
That is not because of the 81 amendment. It is about how the working has actually panned out.
No, it's in the 81 amendment, Malaz. I'm sorry.
81, if you look at the 81 amendment, the constitution of the court, it doesn't give you 74 out of 100.
It does. I'll show it to you. It does, Malaz. This is the mistake I am making, Malaz. I'm sorry. This is not the issue at all. As I said to you, and that ground, St. Stephen's is not a minority institution.
But if you are right,
Yes.
that once you establish,
Yes.
then irrespective of whether you administer or not, it's your choice.
I
You
didn't
can leave
say that.
administration to a
I
third
didn't
party.
say that. Irrespective, once I establish it, if the government interferes in my right to administer, I can challenge it. That's all. Nothing more than that. If there are regulations which seek to destroy that right, I can challenge it. Well, that's the limited argument I'm making. I can even challenge some of the 81, but I'm happy with it. Because it continues, my character is maintained. I have no problems with it. What my Lord is putting to me is that I must demonstrate that I am administering as a Muslim the university. No. I was at that point in time in 1920. I don't have to go back to that position. Where does regulation end and infringement begin, Malad? That's the question. That's my right. I have to decide that. That, Malad, with respect, even the court may not decide. Where does regulation end and where does the infringement begin is something I have to decide, Malad.
Well, the difficulty is when we started the arguments, you said we are not going to the question of or, we accepting or should be read as and. Now your argument today is slightly different. What you are saying is once the minority decides to establish, within inverted commas, establish an institution, then two rights flow. One is they have the right to establish, which is the first right, which is connected with the rights of the minority to establish. And there's a second right, right to administer. Right to administer cannot be read as a condition precedent for declaration as a minority.
That's right. That's what
It's
I've
the
always maintained.
consequence, not the condition.
Yes, I've always maintained that, Malad.
Now you raise the argument in a very different way.
No, Malad, but I have always been saying this. And the other day I said to my Lord, the Chief Justice said, that means if you give up your right, you're happy with it. I said that, Malad, I remember that.
Because now you are arguing it and should not be read as or.
It cannot be read as or, Malad. And it's a right, Malad. There's no question of or. Malad, it is and.
You have both the rights.
Yes, I have both rights. I have always said that. I've never said or, Malad. I've never contended or. It's a right. It's a right to establish and a right to administer. Now, my right, when somebody infringes my right, whether it's the university or the government, I can challenge it. But to the extent I'm administering it, I feel that if this element of free play in the joints is good enough for me, I'm happy with it. So I'm not in any way saying, Malaj, see, 65 was challenged by somebody, Malaj, but the de facto continued. So in a sense, right from 1950 onwards, this has been an institution, Malaj, which has been actually serving the interests of the minority community, de jure and de facto. I say, Kerala Education Bill says it must not be overlooked that 31 gives the minorities two rights, to establish and to administer educational institutions of their choice. The second right clearly covers pre-constitutional schools. This is exactly what, this has been the law throughout, Malad. I've never said anything different, but I happen to have argued most of these matters. Otherwise, you'll be laying down a test, Malad, as I said, no minority institution can ever claim to be a minority on this basis. Article 32 only contains one, Malad. It doesn't contain two tests. I'll have to show that I established the institution. And the Church of North India established, Malad, St. Stephen's College. That's the fundamental Malad's issue. Basha answered it wrongly because Basha said, no, the Muslims were not administering. Where is it in Article 13 that only the Muslims must administer, or the Christians must administer, or any other community must administer? And what is administration? Running, well, that's the other thing. What is administration? Running the day-to-day affairs of the institution. That's administration, I hope, Mullahs. Nothing more than that. If some statute has to be approved by somebody, that's not administration. I have to run the university in accordance with the law. Law is 1906. And well, nobody's answered 1906 on the other side. I've been saying again and again, apply that 1906 to pre-1950. These were all regulations. Of course, mullahs, somebody had to approve. It was the British Empire under which, mullahs, we were being governed. There was a Governor General. There was a proctor. Somebody had to be there. But that's not administering. Administering is running the day-to-day affairs of the university, which means appointing your teachers, holding examinations, admissions of students. That's what administration is. Administration is not some approval that is to be taken by a statute. How many times, mullahs, do you think St. Stephen's have any role to play in an approval taken by a statute, mullahs, or the executive council or the academic council or the ordinances of Delhi University? Nobody takes. We are governed by it. We're governed by, that's 1906. So these are all regulations of 1906.
Mr. Sibal, with your argument, then standard of administration of one minority institution will be different than the other minority institution.
Always is.
Because St. Stephen, see the level of what was the interference by the university and how this court turned down that interference. So now you are accepting that there can be an appointment of a vice chancellor, appointment of a visitor.
Always has been. All minority institutions. Never an exception.
But in that case, the standard of administration in your case will be different than those.
Always another minority institution. Yes. Or any or other institution. Of course, because the teachers are appointed by me. That's admitted, Mullah. That's the accepted position. That's the administration, Mullah. Everyday running of the university. How do I run the university? How do I run the hostel? The appointment of teachers, disciplinary action against employees. The university doesn't take disciplinary action against my employees. It will take others, Mullah. He can go to court and say, look, this is wrong. That's fine. So, Mullahs, all that is governed because that's regulatory. That's 1906. Just read 1906, Mullahs. Just read 1906 with me. Nothing in clause G of the said clause shall affect the operation. Sorry, this is 5. Because it's a, it's an occupation. Yeah. Nothing in G of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right. That's all. Now, if I find any particular restriction to be unreasonable, I will challenge it. So all these are reasonable restrictions. If approval of the proctor is to be taken, is a reasonable restriction. If inspection is to be done, Mullahs, if there are any misgivings about the way it is functioning, that's a restriction. It's reasonable. And that's exactly, therefore, your lordships have said time and again, right to administration is not the right to maladminister. The moment there is maladministration, you lose your right under Article 30. And it's nobody's case that AMU is maladministered. I've been hearing from the other side, it's a great university. It's a university of great excellence. So obviously, I must be administering it okay. And it is. So with the greatest respect, Mullahs, please do not apply a test which may be constitutionally suspect. Please do not do that. And therefore, Mullahs, we are going wrong because Basha went on a wrong footing to say that, look, it's not administered by Muslims, therefore, Basha need not have answered that at all because Basha ultimately says, because you're not established, you have no right to administer anyway. But then 1968 judgment said took off on that basis. So, my lords, I've done with this. I've made my submissions. Then the second submission is that, I'm sorry, my lords, yeah, 1 second. I want to show your lordships, my lords, factually. Kindly come to my submissions page, volume 1G, page 15. Yes, 1 second. No, 14, 15. Kindly see. So, Mullahs, we have all that that's why, Mullahs, I've been saying throughout, all you have to decide is whether Basha is rightly decided or wrongly decided on an establishment. The rest will follow. Then I have a right to administer whatever the act is. If I feel that some provision is violative of my right and it's infringing my right, I'll challenge it. If not, I'll be happy. That's all that your lordships have to decide. Then, Mullahs, the other thing I want to say, Mullahs, my learned friends kept on saying there's a decision of a fact. How can a legislation overturn that fact? What's the fact in Basha? The only fact in Basha that is decided is that because you incorporated, you're not established by the minority. Or is there any other fact that is established? That's the only fact. That's all. That's the fact. The rest of it is interpretation of legal provisions. How is anybody overturning that fact? In fact, the 1981 Act, in fact, takes away the basis. And I tell you, lordships, why. Now kindly come to 1G. So there is no other fact decided by Basha. He says, because the statute says you were incorporated and established, therefore you are not a minority institution. That is the only fact. Ignores everything else.
How did it take away volume 1G?
Yes, kindly now see, Mullahs. It's very interesting. I'll just give your lordships briefly, orally, the background. The background is that when from the beginning attempts were being made to set up, we set up the college, MEO college, and then ultimately, actually, originally we wanted to set up a university. But when the college was set up and talks were taking place of how this is to be done, we ourselves said that we want to establish a university and we'll allow supervision by the government, but we want to be independent. No interference by the government. Otherwise, we'll not go forward. I must kindly have a look at page 15 of my note. Letter dated 14th June 1872 from Sir Syed to Eliot. I've given Mullahs the volumes, so therefore there's no need.
Page
Bringing
15?
to his attention.
Page 15, right?
Page 15, paragraph 18, small a. Lordship have it or no?
Paragraph?
Paragraph 18A, page 15, Mullahs, PDF 15.
18 ऐसा नहीं है.
The problem?
18 and then 19. There is no 18.
Yeah, there's 18 and then 19 actually.
There is no 18A.
18 is
18A.
hence AMU is able to demonstrate.
Yeah, small a, Mullahs, small a.
No.
There's none.
18 starts with, hence AMU is able to
No,
demonstrate.
I'm talking about my rejoinder submissions, which is volume 1G.
1G, yeah, we earn 1G.
Huh? Oh God, you've not uploaded the right version. Been uploaded.
आपके पास ये hard copy है?
Unbelievable. How can we waste time like this?
Volume 3C.
Separately, they can just on even hard copy, they can just put it on the visualizer and upload it for us.
In the other version, is it this contention?
I don't know whether they've uploaded the wrong version. What can I? This is very bad. I'm sorry.
Hard copy ले लो उनसे. फिर visualizer पे.
Normalers, we also don't work on hard copies. I'll read it, Mullahs. Let them email it. I'll just read it. There's a letter of 14 June 72 by Syed to Eliot bringing to his attention that the committee was to be appointed to raise funds for establishment, kindly see, for establishment of a college for the Mohammedans.
Okay, Judge, does this begin, Muslim minority wanted to establish a university for grant of degrees on its own,
Yes.
which would be recognized by the
Exactly.
government?
We ourselves were saying
That's page number 18, paragraph number 32.
Yeah, but we'll give you the final version. So, but therefore, it is what we understand by establishment is not the statutory form of establishment. That's page 64, relevant page 65, volume 3C. I've given the citation. Have you sent the right one? Now, my lords, B. Another letter of 10 July 72 from Evening Bearing Captain to Sir Syed, acknowledging letters of 14th and stating that if the institution, when established, shows a reasonable prospect of divisibility. So they also understand what established means. Well, therefore, I have been saying again and again, the concept of establishment under Article 30 is different from the concept of establishment through a statute. That's a constitutional right to establish. Even Sir Syed and the association and the minority never thought of establishment in the statutory sense. And this is, I'm talking about 1872. If the institution, when established, shows a reasonable prospect of divisibility and general success, and if the course of instruction is such to convince His Excellency that a bona fide effort is being made to afford sound secular instruction, he is prepared to devote 10,000 rupees to the perpetual establishment of a scholarship in the same branch in a European language. I haven't quoted it, Mullah. He wants some European share. That's okay. Then, Mullah, there's a letter of 20th July. Syed to Mohammedan chief saying, intimating them that the lowest sum required for the establishment of the proposed college, again, for the establishment of the proposed college, is estimated at 10,000, and that subscriptions towards this have been invited and contributions having been come from the people of all classes. Then on 18th November 84, this is most important. College Fund Committee to the Viceroy government expresses that we wish someday, when our endowments are richer and our schemes are completed, we hope to be in a position to ask the great representative of India, Her Majesty, to confer upon us the legal status of an independent university. To confer upon us. So this is a conferment of the legal status. It is not establishment of the university. These are two separate concepts, and it is reflected in the contemporaneous communications. It's done now. And we wanted an independent, and I will show to your lordships, and I'll just presently show. Your lordships have it now.
Yes, sir.
So I was referring, Millers, to 18 small a, b, and c, and d, which I've read to your lordships. Now kindly come to 19. If all my lords have it, Millers, I will read that. My lord Sir Surikant has it?
Yes, sir.
Justice Pardiwala, do you?
Yeah.
I'm sorry. It's now on the screen also. It's also on the screen.
Paragraph 19.
Okay, now it's there.
So 19, third, it is clear from the correspondence and other historical material that such a college was envisioned as free of governmental interference. As such, there is no surrender at any point of the right to establish the institution that they had been envisioning. Even at the time, the founders do a distinction between government interference on the one hand and supervision and support on the other. In this context, the proposed scheme for MEO College presented by Syed is relevant. The scheme reads, I have to mention first of all that management of this institution should be perfectly free from any control of the government beyond mere supervision. So you can supervise me, but you can't control me. That's Article 30. The following passage is crucial. The best educational institutions in Europe are either entirely or next to entirely free from any control of government of the country, and this in countries where rulers belong to the nation whose education is conducted. With how much greater force does this argument hold good in the case of India, where the government is almost wholly composed of persons belonging to a nation totally different from us in language and religion and mode of thought. By saying so, I simply mean to support my argument that it is next to impossible for the British government to understand fully our wants with respect to education or to superintend it in any perfect manner. The utmost we can expect from an enlightened government is to receive what we in fact do receive from our government, encouragement and patronage. If our university is intended to give sound education, the English government, as a matter of course, will patronize such institution. And if any direct pecuniary aid is given to us, we should not be unwilling to put our university under government supervision, provided no interference is made in the management of the institution.
Which is the year?
This I'm reading is
1902.
Volume 3. I've given the.
No, it's not in the list also, it's not, date is not.
I'll give the date.
It's 1903. Yes.
No, it's not 1903. Anyway, I'll give the date. 1870s. Anyway, so Malas, the point I'm making is this is how it was envisaged. That you will give it a status. Right? But we'll be independent. Don't interfere with us. And that's why those provisions that the governor can inspect, these are all supervisions. Otherwise, there's no interference in the administration. On appointments, on admissions, on appointing teachers, on everything is controlled by the court. I'm not on Muslim and non-Muslim now, Malas. I'm talking of pure administration. And we're not concerned with Muslim, non-Muslim. The point was that the provisions that my learned friend read are provisions under 1906, equivalent to 1906. Provisions of supervision that you don't fall foul of the standards. That's what it is. It has nothing to do with establishment. And giving it legal status is the establishment under the statute. So then, Malas, then this very MAU, Malas, all was taken over. This MAO was taken over by AMU. And the same thing happened in AMU. Exactly the same. No change. Whatever government control was there in MAO, the same was there in AMU. No change. That is, we have a chart to that effect. That is chart A in 1H. Just you note that. We've said so. We've demonstrated. So, Malas, our concept of establishment was clear. That they can supervise was clear because they're going to give us aid. The same here. That's 1906. They regulated us that finally I can't. Apart from the first ordinance, if I wanted to amend it, the court could amend it, but ultimately it will have the final approval. Every ordinance in Delhi University will have the final approval of the visitor. Okay. That's not administration. There's a whole complete confusion on the concept of administration. So, Malas, so this happened. This is the background on the basis of which the university was set up. Now, Malas, let's move from 90, because there are four, so to say, milestones: 1920, 1950, 1965, and 1981. 68 and 1981. Now, these rights got frozen in 1950. Right, got frozen. If you now come to the conclusion was Basha was wrong by taking that test of fact, namely because you were incorporated, therefore you were established, therefore you did not establish the university. If that's wrong, brothers, then in 1950, I was a minority university, and that was frozen. And the same test would apply. And what is your lordships considering? What was the position in 1950? If I was a minority institution in 1950 established by the minority, which is clear, well, on facts it is clear, they've all been set out by your lordships. Fund was mine. Donations were given by Muslims, non-Muslims, even others. 30 lakhs was never given by the Nizam, as one council said. And all that was, and that was the condition precedent for establishing that you have to bring in 30 lakhs. We brought in, its value is over 320 or 40, 50 crores today. So, Maharaj, in what way did I not establish, other than the fact that I incorporated? I incorporated why? And that's also history, Maharaj. I can't go through it because there's no time. The history is this, Maharaj, that there were two schools of thought. And if the Muslims are conservative today, you can imagine how conservative they were in the 19th century. And there were two schools of thought. Well, there were two kinds of schools, what are called the Halka Bandi schools and the Tehsili schools. Halka Bandi is in the Halkas, those says, and then the Tehsis, the schools were there. And the Muslim parents never used to want to send to these schools. Some of them were English speaking, they didn't want, the conservative elements didn't want that. But the Sir Syed element wanted a liberal education to copy the British. And that's how, Maharaj, this whole concept came about. But without interference by the imperial government. And the imperial government agreed with it. They didn't interfere. Have your lordship seen any document in this entire proceeding, right from 1968 onwards, that the imperial government ever interfered? Ever interfered? No statute was ever refused as suggested by the court. Never. They were never interfering. And the argument is no. Because they had the final right of approval, therefore this is not established. That's a non-starter, according to me. So, Maharaj, a committee was set up. In terms of committee, there were two schools of thought. One school of thought says, let's move forward with Western education. Let's have our children be taught in the English language. That was one school of thought. The other school of thought was, no, we suspect these people. We don't want to go to these schools. We are against Sir Syed to set up this university. And the British said, if you are able to get 30 lakhs, if you are bona fide in your efforts, I will help you. And the statute itself, the 1920 Central Legislative Act, didn't have any element of interference with the day-to-day functioning of the AME. Never. And then in 1950 it got frozen. Then what happened in 1965 was this act, and which was challenged by somebody. There Chagla said it's a temporary provision, it's an emergency provision, but I will continue to maintain the character of the university. What did he mean by that? Character of the university means it's for the minority. It's not for the majority. One second. He had to support the act. Naturally, he had to then agree with Basha. How can a minister stand in parliament and moving an act to amend and say, no. This is before Basha.
Before.
Yes, right.
Basha came subsequently.
Yes, that's right. It's before Basha.
No, but he did say, but that may not be binding on us, but he did say that he
Yes,
did not
he did.
believe.
I accept that. Manoj, he did say, Manoj. But Manoj, I'll tell your lordship again. Quite frankly,
He probably wanted that it should not be declared as a minority institution, because let's also forget St. Stephen's came much down.
Yes. That's correct. Your lordship is right.
At that time, there was no question of reservations.
That's right. That's a separate issue altogether.
That was not the issue at all.
Yes, that was not the issue at all. But anyway, Manoj, so that's what happened, Manoj, and therefore, de facto, it continued. That character of the minority institution continued. There was no interference. So from 1950 till 2005, there was no interference as a minority institution. So, Manoj, what is the occasion today to interfere? If Basha is wrong. If Basha is right, Manoj, then it's another matter altogether. And therefore, Manoj, your lordships will have to see the position in 1950 what happened and what the word established means in 1950, which I said in my opening argument, that the concept of establishment under the constitution is different from establishment under a statute, because that is to seek recognition. And in the speeches, Manoj, that you will find, the people are saying, look, how will our children get jobs? And because, Manoj, AMU, we set up the university with the approval of the British government, the second argument made was that we were loyalists to the British. So were the soldiers of India loyal to the British? when they fought in the World War. So was the Allahabad University loyal to the British? Everybody seeking a job in the government of then government was loyal to the British. Is that a test, Mullahs? Is that an argument? All ICS officers were loyal to the British. Is that an argument? That's a communal argument. So, Mullahs, let's not deviate from the essential constitutional question. Loyalty to the British or being there were several people who were not part of the national movement, but that didn't mean they were not loyal to India. Their concepts were different. Some people wanted social change. Netaji said, I'll revolt. I won't be part of it. I'll be part of the Allies. Axis. The others said, no, we'll be part of the Allies. So different concepts. So we can't put a status to an institution based on these kind of considerations. It'll be wholly irrelevant and also, I think, very divisive. Then the concept of minority. What is a minority, Mullahs? How do you determine then a linguistic minority in a state? There'll be several linguistic minorities in the state. How will you determine that? So this whole concept of you're not a minority at all. So if in a state somebody is in power in Maharashtra, Mullahs, then who are the minorities in Maharashtra? What kind of argument is that? We were not ruled by the Pope, Mullahs. It was the British Empire. The fact that they were Christians didn't mean that we were ruled by the Pope. So, Mullahs, that's the other level of argument. Then, Mullahs, the third level was that, look, this is an institution of national importance. Correct? It is an institution of national importance. Now, Mullahs, look at it constitutionally. As a matter of law, can you say that a minority institution established under Article 30, which is our fundamental right as a community, cannot be an institution of national importance? Can it ever be said? In other words, a field of legislation where Parliament has the authority to make law will destroy my constitutional fundamental right. Can it ever be said? Minority institution is the furtherance of a constitutional objective. Why? And I said so in the beginning, no reservations in any institution. Coming back to the reservation issue, Mullahs, if today there were reservations in this institution, minorities wouldn't have a place because 60% of the seats will go. And there are many institutions of national importance where reservation is not allowed, even under our constitution, even today. So that's, again, not an issue before your lordships. 1981, not an issue before your lordships. The only issue before your lordships is whether we establish this university or not. That's the only issue. Everything else will follow. Whether 81 Act is good, 81 Act is bad, all will follow. If we have established, then well, it will be tested on that basis. If we are not established, we're out. We're not a minority institution. That's the limited issue that your lordships will have to decide. And decide it on the context of 26 January 1950. What do you mean by the word establishment here? And can, on the basis of what is placed before your lordships can come to the conclusion, yes, it was established by the minority. If your lordship says Basha is right because it was incorporated, you got legal status, therefore you're not a minority, that's another issue. That's what Basha decided. But that's what your lordships have to decide. As simple as that. This numerical test has no application. With respect, it has no application. And I'll give your lordship, since your lordships want it, just give it to my lord, the numerical test. You have it on your printed. Yeah, give it. Just, Mullahs, your lordships may note the provisions of the Constitution which refer to institutions, while you do this, institution of national importance. But as kindly just noted, Article 62, Entry 62, List 1, Entry 63, List 1, Entry 64, List 1, '67, List 1, then Entry 12, List 2, subject to Parliament, Entry 40, concurrent list, like museums, of national importance, archaeological sites of national importance. Then Schedule 6, Section 3, capital A, small n, and Section 3, capital A, small b. These are various entries in which, the reference to institutions of national importance has been made. But these are only fields of legislation, These are not constitutional rights, which are given. Merely because you have the right to pass a law where a minority institution doesn't mean it's not a minority institution.
De facto.
Yes.
Happened to be.
And the other thing, just to say, we were established by an act of the Imperial Parliament. We could not have been in list 2. Education was in list 2. We could not have been there. That's why it was included here. If it had been universities, it would have been regulated by the state. The union didn't want that. And it was passed by the Imperial Parliament. There was no question of it being included in list 2. Then the third issue is, if you were to include it in list 2, then each state will have its own control, each university in that state, Nobody wanted that to happen. There were only 3 universities of any character in this country at that point in time. Delhi University, Banaras Hindu University, and AMU. There was no fourth. That's why it says, and any other. Then the IIT came, the IIMs came, Bhabhi Katoma Energy, all that came later. 165 universities happened later. That doesn't mean that, that they don't have the character. And each of them will be peculiar to it. So then the other argument was, look at this university established in Annamalai. Annamalai was established because there was a private person. It's not a minority institution. Annamalai was a private person who was the founder of that university. He handed over everything to the government and said, but I want, as a founder, I want control over the staff. I want control over nominations and stuff like that. They said, fine, you take it. But how do you apply that test to a university under 30 or a minority institution? I mean, each institution, and the founding moment is entirely different. For each university will be different. See, you can't make an argument of uniformity that every university must be in the same manner, established in the same manner. It can never be. Universities anywhere in the world will be established in different manners depending on the time, the level at which society is placed. All that will be factors, So that takes care of that argument, The other thing is that, let me now just see if there's anything left, I want to quit. There can be no surrender of a fundamental right. How can there be a surrender? Hold on. I can't waive it, I can't surrender it. If in 1950, I was an institution established by the minority, there's no question of surrendering anything. But if I have not established, and if Basha is right, that because I was incorporated, then of course it's another issue. So, the administrative argument that has been made is without reference to the scheme of the Constitution. It has no relevance. The only relevance is, was it established? Now, on surrender, in St. Xavier's, it says it is doubtful whether the fundamental right under Article 30 can be bartered away or surrendered by any voluntary act, or that it can be waived. So that whole argument, the reason is that the fundamental right is vested in a plurality of persons as a unit or if we may say so, in the community of persons necessarily fluctuating, can the present members of a minority community barter away or surrender the right under the article so as to bind its future members of the unit? The fundamental right is for the living generation, by a voluntary act of affiliation of an educational institution established and administered by a religious minority. The past members of the community cannot surrender the right of future members of the community. The future members of the community do not derive the right under 30 by succession or inheritance. Very powerful words. Justice Matthew and Justice Chandrachud, as he then was. Also Kerala, Malaks. Nor do we think that there is any substance in the argument advanced by Learned Counsel for Kerala that this bill has not introduced anything new, and the Anglo-Indian schools are not being subjected to anything beyond what they have been submitting to under the Education Acts and Codes of Travancore. In 1945 or 47, when those acts and codes came into operation, there was no fundamental rights, and there can be no loss of fundamental right merely on the ground of non-exercise of it. There is no case of estoppel here, assuming that there has been an estoppel against the Constitution. There can be no estoppel against the Constitution. So surrender, estoppel, waiver, I just have completely alien to our Constitution as far as fundamental rights are concerned. And 30 is part of fundamental rights. Yeah, like my learned friend talked about national character. That's nothing to do with the entry. Entry only says national importance. Now, Malas, the other, just so that, Malas, because I have no time now, I have 20 minutes, a lot of time. Actually, I'm happy your Lordship asked me to encapsulate it. I will be able to finish it. Now, Malas, I want to show you the present. I have a chart of the present universities established after 1950. My learned friend also made an argument. See, in the universities today that are established by the minority, there is a statement there that they are established under 30. But that statement could not have been there in 1920, Mother. It is the effect of Bhasha that statement comes. Because of Bhasha. That can't be used that because there was no such statement there, Mother. You'll have to see from the facts of the case as to whether we were the ones who actually who established the university with funds that we collected, with the vision that we had, with the intention of setting up a university, with the idea of helping our community. A loyalty to the British according to me, the gentleman was loyal to his community, not loyal to the British. By thinking of trying to help his community, the loyalty that he was demonstrating was that to the community. Were the poor amongst the Muslims who had no access to education. And may I just tell your Lordship asked a very magnificent question. All these institutions of national importance, what is the national character of these institutions? We did some research, Mullahs, and we found a very interesting feature. That in IITs, Mullahs, which is page? Page 33. Page 33 of 1G of our note, Mullahs. Very interesting. Such a committee, page 33, 1G, page 33. Yes. It's on the screen. Oh. One thing, huh? Yes. See, Mullahs, page 33.
This is 2006 figures, I think.
Yes, I'm only talking about the 2000 figures. Whatever figures I have, I'm giving it. I'm just showing.
That's the time when the reservation was made, which is challenged.
That's the time when the reservation was made and it was challenged. IIMs, Your Lordship has that paragraph 62 at page 33. About 1 out of 3 Muslim applicants is selected in IIMs, which compares favorably with, in fact, a somewhat better than the success rate of other candidates. Despite a better success rate, Muslims constitute 1.3% students studying in all courses in IIM. 1.3%. This is the state today after independence. And whatever little the community has, you want to take that away also. And in absolute numbers, there were only 63 out of 4,743. IITs. In the case of the IITs, out of 27,161 students enrolled in the different programs, there were only 894 Muslims. The share of Muslims in postgraduate courses is just about 4%, but it is even lower in undergraduate courses of 1.7%. 1.7%. This is the factual, this is the national character of IIT that my learned friend was talking about. Only 1 out of 25 students enrolled in undergraduate courses and only 1 out of 50 students in postgraduate courses is a Muslim. The status of Muslims in PG courses is equally disappointing. Only about 1 out of 20 students is a Muslim. This is significantly below the share of OBCs 24%, SCs, STs 13%. So this is the state of affairs. So Maharaj, what do we have? We have one university, which is a university of excellence. And you want to say today that no, take it away. The argument is it's too good to be a minority. And even the private survey shows only say 1.6% are Muslims. In 2019, I'm talking about, but that's a private survey, Mother. But this is government for IITs and IIMs. I'm talking about IITs and IIMs. 2019 private surveys say that, and done for the IITs. So now, let us kindly go to my chart in the beginning of this note. Yes, the index, table of contents.
Based on the entrance test, we can. What turns on? Nothing turns on.
You know, I didn't say anything turns on it. You said that these institutions must represent national character. So what's the character they're representing?
It's non-denominational.
It is not denominational. It's a right, fundamental right given to the minority. Diversity, we are admitting. But as I said, this university has graduated thousands and thousands of non-Muslims. St. Stephen's was thousands of non-Muslims, some of them sitting here, some of them sitting there. Madhav Menon was a product of AMU. He did his LLM and PhD there. So what are we talking about? Secular nature of education can never be discarded, should never be discarded. If it is, it's violative of people's fundamental rights. But we are imparting secular education. But we have certain elements that have something to do with our community. And as I said, if my learned friend is right, and he's right, there was no reservation. But the fact of the matter is there was institutional reservation. So from MAO college, people came into the university. So there was enough Muslim students because of that. From the schools, they came to the university college. That's how much the representation was maintained. We didn't need reservation. But if you throttle that, then where will we go? It is to make up for the lack of representation in other institutions that you have an institution which is an institution of excellence. Now, why do you want to take it over? I don't understand this, Mullah. I've not understood the rationale for it. That why do you want to take it over? Is there something that this university has done which, Mullah, is anathema to our constitutional values?
So nobody's taking over.
No, you are making an argument that because it was incorporated, it is not established. That's your whole argument. You are taking over, but you are saying it's not established, therefore you'll take over. What will be left? Well, you can appoint anybody you like then. There'll be 60% reservation also. 50 plus 10 now. Then what will be left? So these are very dangerous arguments, Madhav. I mean, one little citadel of learning, one little small citadel of learning in a country of 120, I mean, it's a billion people, what? What are you, 1.4 billion people, what are you trying to do? Small institution. So, Malas, just the contents. One factual argument on administration, Malas, I've already done that. I've shown that. Malas, I've given the pages because it's all structured here, Malas, with the pages and the cross references. Broader analysis of Article 30. Just come to page 11. at the bottom. Broad analysis of 30. The respondents have argued that in order to determine whether a particular institution is a minority institution, a twin test must be satisfied. First, the minority must show that they established it, and second, they must demonstrate that they are administering it. That's the wrong test. It's an absolutely wrong test. This argument of the respondents is mounted on the strength of the word "and" in establish and administer. That's the learned solicitor, my dearest friend, Malad. He's been arguing this. So, Malad, I've set out the law on the subject, Malad, and I say St. Xavier's, Kerala Education Bill, all those opinions, Malad, I have given the passages. The community in question is the religious or linguist minority, and the minority community established the educational institutions. And it must not be overlooked that 31 give the minorities two rights, to establish and to administer. Malad, I've done that. So go back to the contents, Malad, now. So this is on 2. Then no surrender. I've shown that to your lordships. Then declaration AMU is an institution of national importance. I've dealt with it. And legislative debates do not render AMU a non-minority institution. Right? Your lordships have to look at only the aspect of establishment. Anything else? Yes, I want to show that chart, which is that page. 1H. Well, I hope you have it. 1H, yes. Now, this is Malad's. There are two charts. This is the first chart is the comparison between Aligarh Muslim University and MAO College. Your lordships will find that at page 1. MAO also had external supervision, just like AMU. Now, no different. Which one are you going? You don't give the wrong one. Which is the chart? Well, give me your chart. Why are you giving me the wrong chart? As it is. This is the correct chart. The numbering has gone wrong. Shit. I'm sorry, Malazai. I apologize to your lordship.
1H, right?
This is his.
No, 1H is Mr. Farasat.
It's the same chart. So which one is your chart?
So I'm just emailing it to them right now. What is it?
Anyway, Malaz, what I want to say is that whatever restrictions were there in MAO College in terms of supervision, the same came in the AMU. No different. Consistent with that statement, we don't want any interference. We are acceptable on supervision. And MAO was accepted by Basha as minority. The only change being it was incorporated, therefore you lost your minority status. Overriding powers were there even in MAO. It's just simple. It has to be, somebody has to ultimately be responsible. In any educational institution, you just can't leave it to the institution and the principals of the college. So the same. Then the second one, second chart, show the second chart at least. It's there on the screen. Now you will see the second chart is page 8, it starts, Malad, it's on the screen. Now what we've done is we've looked at University of Calcutta, Aligarh University, Alia University and Haryana private universities. You will find similar provisions in all universities. So they are not minority institutions because there's a right of inspection. Page 15C, Malad. I agree. I'm saying it has the same provisions. That right to inspect which you talked about as far as the AMU was concerned. You said you have a right of inspection. See? It's a right of inspection here. How does it change the minority nature of the institution? Statute amendment is the same. You can amend the statute the same. They can amend the statute. So how will that make a difference to the minority character? And Alia is 100% aided. Page 15, just see, Malad. Governor of Haryana shall be the visitor. The visitor shall have the following powers. When present, he shall preside over the convocation to call for any paper of information relating to affairs of the university. On the basis of information received, he is satisfied that any order, proceeding, or decision taken by any authority is not in conformity with the provisions of the statutes. He may issue such directions as he think fit. Notwithstanding anything contained, the university shall be bound to comply with all the rules, regulations, this thing. And powers of government to inspect universities and academic and everything, and audit, as my Lord Justice Datta put it. Same provisions. Does it mean that these universities which are incorporated as minority institutions are not minority because of these conditions? Earlier also the same. Government control is not the test for inspection and for maladministration. This is to ensure that there is no maladministration. And Haryana Act is for all institutions, whether minority or non-minority, all institutions. So the tests are wrong. The application of the test is wrong. The constitutional conception is wrong. The approach to Article 30 is wrong. I mean, it would be an unfortunate day, my lords, in a secular country wedded to plurality, wedded to the cause of an India which is inclusive. We are arguing here that take away this. It was never a minority institution. All I can say is it will be a sad day if that ever happens. Thank you very much.
Thank you, Mr. Sudhir.
I may be excused.
We have, I have a very short submission, but I'll take about 15 minutes.
We'll not be able to assemble now after today because we have another set of matters. So today we have to have a cutoff on this matter. Whatever you want to say, you can supplement in a short note, maybe a couple of pages.
That's what I do, my lords. I'll only point out to your lordships that much of what has been said is very beautifully reflected in David Lelwell's book called The First Generation of Aligarh. My lords, the entire conspectus of how the Aligarh College, the MAO College, was conceived, what was the kind of support it had from what they call the COM, the community, the sort of community support it had, and how that moved forward to becoming finally the AMU. My lords, there are 3 chapters. I will mark them out. There are 3 chapters there, which I believe will be edifying and important in actually fortifying whatever has been argued with your lordships. Just 2 or 3 points that I will put down. My lords, I will just indicate. One is on nature of rights. My learned friend, Mr. Dwivedi, has talked a little bit about positivism and the difference between morality and law. Lordships are all familiar with it. My lords, I have argued, and I would reiterate that the issue of morality and law is not what is involved here, but the issue of constitutional morality, which your lordships have conceived as a manner of looking at the constitution in a wholesome manner, started with Keshav Nand Bharati. Where did that take us in the present circumstances? My lords, have a little bit on that. On non-denominational issue, my lords, I'm going to highlight the fact that, of course, there was the Wood dispatch and so on and so forth, saying that we now prefer non-denominational institutions. But the fact remains, the non-denominational institution didn't prevent them from saying that we are setting up Banaras Hindu University, we are setting up an Aligarh Muslim University. And when the Aligarh Muslim University is set up, my lords, the logo and the motto look very clearly, very clearly and specifically Islamic. And in fact, a verse from the Quran is quoted in the motto, which is taught man what he knew not. Quran, verse 96. My lords, I'll put these things in my supplementary submissions. Your lordships may please consider them. I'm grateful, my lords.
Thank you. Yes, Mr. Faraz.
I just conclude within 5 minutes. First, quickly, the first submission, I just have 2 short points of rejoinder. The first submission is insofar as establishment is concerned of 1920. And the argument was that by establishing, you have taken away the denominational status because you gave away right. That is what the solicitor argued. Now, in response to that, I have compared all the universities, the two denominational universities, namely the BHU and AMU, and the non-denominational, that is Allahabad, Bombay, etc., which were also through an act of an imperial legislature. I have compared that to show that, in fact, in these enactments, that is denominational statutes, the legislature went way far ahead in terms of giving the autonomy. And that comparison your lordships will have in 1H is my written submission in rejoinder from page 15 onwards. For instance, broadly, I'm not going to take in detail. The broad point is this. Even in the opening of those statutes, the statutes mention that this is for all subjects of Her Majesty's or His Majesty's government. So, the very opening of those statutes, Allahabad University, Calcutta University, etc., they say it's for all subjects. No such provision is there in AMU Act. Similarly, the Chancellor and the Vice Chancellor are government officials. They are, my lords, either the Governor General by name, by designation, they are government officials. Here, the power is left with the Governor General. Here, the power is left with the Governor General, and the persons who have been appointed pursuant to that power, when we look at de facto and de jure together, are Muslim persons. So, the power was left so that it could be exercised to appoint a Muslim. Otherwise, you would have by designation named the Governor General or or some government official as in the non-denominational acts. Similarly, there is a power of something called fellows in these enactments. There is a whole bunch of fellows which are there. And they also, my lords, are all government officials. No such provision exists. Power to grant decrees. Who grants the decree? My lords, the government official grants the decree. Here, the university grants it. So the broad point is this. Plus, the space of court, executive council, and AC which has been created, it is, of course, subject in some aspect to the supervision of the higher authority. It's like two hands need to clap. The day-to-day administration, the decision, the initiation keeps on coming from the university body, which is minority body. And on some aspects, there's a confirmation by a higher body. Of course, the colonial government will keep some level of control with it. It is not going to establish a Muslim university and say, out you go, you do whatever you want. Well, that's quite clearly understood. So in that respect, the initiation stays with us. And that is the fundamental distinction. The chart has many examples. On paucity of time, I can't go into it. But if you lordships will just examine that chart, on every aspect, it will show the denominational nature is evident from the level of autonomy granted vis-a-vis the non-denominational universities of the relevant time. Well, that's submission one. Well, submission two, your lordships have the entire canvas before your lordships today. Everything has been argued on facts, on law, on decisions from 1820 onwards till 2024. Because the question, there are various approaches available to your lordships as to in this reference. Because what I would commend to your lordships is that your lordships will restrict, as Mr. Sibbal argued, to 50 and not test any specific amendment in this reference. The reason is this. In particular, my lords, the declaratory amendments of 1981. Because the non-declaratory portions are not in challenge at all. They have never been challenged. What was challenged and what has been set aside by the Allahabad High Court is the declaratory portions. The reason is this, my lords. Whereas it is the constitutional obligation of the executive to defend a parliamentary enactment. If today the executive has chosen not to defend it, the parliament is without a voice before this constitutional court. The parliament has spoken through an amendment, but it doesn't have a defense before this court on that amendment. Because that is something very fundamental and core. For that reason alone, my lords, everything is before your lordships will consider it. But don't test the wiries because there is no constitutionally valid defense before the court today. And my lords, my written submissions your lordships will have, page 13. I'll just formulate it quickly, I won't take it. Because the executive has a say in legislation. The say is at the stage when when the assent is granted by the president under Article 111. The president can, as your lordship knows, send it back. That is an aid and advice function. It can still come back and then the president has to approve. So, the limited say on the legality or constitutionality or desirability the executive has. Once it's a one-time exercise, once the assent is given and once a law is notified, the executive loses the power to either go contrary to the act in terms of enforcement or not to defend it. Because constitutionally, otherwise it will upend everything for the reason. Just test this. Let us say, well, the executive is today, it wants to overrun an earlier constitutional amendment. I'm just hypothetical, pure, not in this case. It wants to overrun an earlier constitutional amendment. It doesn't have the numbers in both the houses. What does it do, Mullah? It has a frontal litigation. It chooses not to defend as a defendant. By the same logic, it can even challenge an earlier amendment. If it is entitled not to defend, surely the executive can even challenge an earlier amendment. And Mullah, it is not the responsibility of Aligarh Muslim University or any of the private petitioners on this side to defend the parliament. The parliament has spoken in our favor, therefore we are defending it on that particular amendment. But it's not the responsibility. The constitutional obligation solely and exclusively lies on the executive, and they don't have a choice because the prerogative of testing the constitutionality is the exclusive domain of this honorable court, of the constitutional courts. It is not with the executive. In fact, that changes the separation of powers. If the executive were to decide what is constitutional and not, and then defend accordingly, that will completely upend the structure. So my respectful submission is, even a law which the executive of the day believes to be unconstitutional, it is constitutionally expected and obligated to defend it before a court. Well, that's why, just as an example, the Brown versus Board of Education, the Attorney General for Kansas had, for the executive express.
If he wants to raise, I didn't dwell
So,
much on.
Well, I'm not.
The new arguments.
It's a response to what was argued. So, Mullah, the submission was this, that although the executive's view declared was that segregation as a policy is not proper, it's not desirable, it is possibly unconstitutional. But before the 9 judges of the US Supreme Court, the executive, through the attorney, defended it, for the reason that the executive has no other option. So, Mullah, because the parliament doesn't have a voice today, my respectful submission would be that aspect of just the declaration, your lordships will leave it at a subsequent stage. Your lordships may consider deciding in this matter if the executive has that option of disagreeing on it. That's my respectful submission. I'm extremely clear.
So Shamshad, then.
My Lordship, I had argued 4 points, in fact. One was recognition, second was group rights, and third was the concept of educational institution is very broad. And for that, I had taken through, Your Lordship, with the Basha principle itself. The only thing that I could not complete that day, and I had given the pagination, my Lord, and Your Lordship had noted, Keshwananda Bharati, para 535A, volume 1E. I have given in volume 1E, page 78, my Lord.
Yes.
535, I'll not read, my Lord.
Yes.
In the background of entire minority rights from pre-independence till formation of, or till constitution has been set out. And then in that background, it has been stated that it is in the nature of essential feature of the constitution. So that is one aspect. Then coming to, my Lord, the Lordship's judgment in Puttaswamy. In Puttaswamy, my Lord, para 298, Your Lordship may have this paragraph at page 500 in volume 5B. Your Lordship has stated that Constitution has recognized inalienable rights. My submission is, my Lord, Fundamental Right chapter has recognized many inalienable rights which existed pre-Constitution. Article 30, what it does, it recognizes the right. Once you recognize those rights, either in the present regime of Constitution of India or prior to the Constitution, the question of surrender of your right does not arise. So the surrender argument that has been advanced in relation to one of the components which has been held by this honorable court in Keshwananda Bharati case, that it is in the nature of basic feature of Constitution. So to say today that surrender of autonomy or rights falling in part 3 of our present Constitution is neither contemplated in today's constitutional scheme, it's my submission, my Lord, nor this court will recognize that it was possible to surrender those inalienable rights in favor of erstwhile sovereign powers. That's what they have argued, my lord. Dr. Dhawan has already highlighted in his written submission, saying that how minority rights were recognized even prior to constitution. So there is a list already. So in that context, my lord, Article 29's interpretation of Your Ladyship Justice Ruma Pal in TMA Pi, though she has dissented, but that dissent is not to say that minorities' right was lesser than what majority has said. The dissent is to say that, see, majority is saying that Article 29 to 50% reservation of St. Stephen's has to come through a state intervention. In many circumstances, even that is not justified. So Your Ladyship has spoken to say that, see, if you are fixing, there may be a circumstance in which beyond 50% would be required for those who have established their institution. So in that background, there is dissent of Justice Pal. And to support this argument, para number 381 of Your Ladyship Justice Ruma Pal in TMA Pi at 5A, page number 736, Your Lordship may kindly consider. So in this background, my lord, last line, my lord, when Your Lordship is considering interpretation of Article 30 and taking a decision whether Basha should be reconsidered or not, Your Lordship, this judgment is going to decide the future prospect of Article 30. I can say this. It will have implication on many aspects of minorities' right in the country. The only submission I am making to Your Lordship, that while deciding this, Your Lordship will take a view. That view advances Article 30's protection. And the way they have argued, as if it is only a decorative provision, that decorative provision, it will not turn into decorative provision of minorities in the country, my lord. That's my respectful submission. Your Lordship will give a broader interpretation.
Thank Your Lordship.
Thank you, Dr. Dhawan.
Grateful
to everyone.
Very grateful. Very grateful.
Deeply obliged.
Really deserve that. Arguments concluded. Thank you.
Deeply obliged.